Right. How long does it take to get from North Adams?
3 hours.
Amanda, how was the hairpin turn?
Tight. Definitely. That was a tight. I'm glad I was warned.
I warned you about it.
I appreciate it. That was by the what is it called? The Eagle Diner or something like that? That's a tight turn.
All right.
Well, happy to be here.
All right, we'll get started. Everybody will come wandering in. We're going to start by reading a letter from the governor addressed to the executive council. Judge Bernstein, you remember when you were here? Yeah. I was just saying, the retired Justice Bernstein, her and I started in the VA's office like in the early 80s together in Malden. We had fun. Okay, I am pleased to nominate Amanda F. Ward to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy. It's a big deal. Okay, we are going to start by having you. Well, I'm going to introduce Councilor Jacobs. I already did when she came in. As the other councilors come in, and they we'll introduce them. We don't usually have hearings this early, which is one of the reasons that people are a little late, because we have 3 hearings today. We're going to be going all day. We need to crush 3 different dreams today. Why don't you introduce everybody who's here?
This is a former colleague from Middlesex, Beatrice Van Meek. This is family friend John Weathers. This is my mother, Deborah Ward. This is my son, Cameron Miller. It's the Honorable Justice, First Justice of the Dorchester Court, John Hines. Former colleague and friend from Middlesex, Amanda Rowan. That's my aunt.
Might be my friend too. But...
That's my aunt, Nadine Pressey. That's my uncle, retired Boston Fire Captain, Billy Owens. That's my cousin, Ayana. That is, sorry. That's my friend, Shelley Godowski from Middlesex. That is my friend, Marie Elmador from Middlesex. That's a family friend, Louis Bryant, my former high school teacher, family friend. 2 people from the governor's office. Former colleague in Dorchester and friend to Jonathan Ites and Helen White, who's now the clerk magistrate in Charlestown. The Honorable Judge Eric Reese. For high school friend Charity Coleman, Judge Krupp's intern. The Honorable Judge Peter Krupp, another friend from high school, Amanda Bryant. The Honorable retired Judge Patricia Bernstein. Those are all the people here in support of
A lot of friends.
Ayana Spencer, I'm sorry.
I already introduced Councilor Jacobs. Councilor Iannella is present.
Morning.
And Councilor Petito Devaney is present as well. All right. We're going to call your first witness, the Honorable Jonathan Tynes. How long has it been since you've been here?
I want to say maybe 8 weeks, Councilor Kennedy.
I mean, since you were here as a nominee.
11 years.
Right.
Yes, good morning. Councilor Jacobs, Councilor Iannella, good to see you as well.
Hey, again.
All right, so it's a true honor and privilege to once again appear with this wise council. The work that you do, serving as the final arbiter of the composition of our judiciary, is valuable and critically important. That's why it's such a distinct pleasure to be here and to share some words with you on behalf of my friend and colleague, Amanda Ward. I've known Amanda for 25 years, since 1999, when we were both in our first year working for the Suffolk County District Attorney's Office. I was a brand new Assistant District Attorney in the Boston Municipal Court, and Amanda was victim witness advocate in the West Roxbury Court, District Court at that time. And while we weren't working in the same court, we got to know each other through office functions. And even at that early stage, I recognized that there was something special about Ms. Ward. As we got to know each other over time, we learned that we were both from Cambridge, and even more special that our mothers were really close friends. Over the years, after she left the DA's office and went on to work as a paralegal for both the Attorney General's office and Howe and Stewart, I would see her from time to time and continue to marvel at her constant pursuit of professional excellence and development. I was thrilled to learn that she had enrolled at the finest law school in the country, and even more excited when she graduated from Northeastern in 2006. As the supervising assistant district attorney in Roxbury, it was tremendous to have Attorney Ward practicing as a defense attorney in that court. As an attorney, Amanda was always thoroughly prepared, ready to go, and a fierce advocate for her clients. She was always on top of the latest case law, yet equally thoroughly versed in the narrative of her clients' lives. She quickly built a reputation as an incredible trial attorney, but also of a straight shooter whose word you could trust. It was no surprise then when, as a brand new judge back in 2013 at the Dorchester Division of the Boston Municipal Court, that Attorney Ward appeared for me as a supervising attorney for CPCS. Over the next 4 years is when I really had the opportunity to begin to witness the phenomenon that is Amanda Ward. I quickly realized that she was someone that I could go to if I had a concern, and I know that it would be addressed promptly, thoughtfully, and honestly. There were times that we agreed to disagree on a certain issue, but it was always respectful and ultimately productive. The attorneys that she supervised were always on an upward trajectory, which speaks to her ability to not simply supervise, but to teach and encourage and nurture. While I was saddened when she left CPCS in 2017 to become an assistant clerk magistrate in Woburn Superior Court, I was that much more elated when she returned to Dorchester to be an assistant clerk magistrate in our court. Now, take everything positive I've already said about Amanda Ward and multiply that by about 10 million. And that will preview how I feel about the nominee in front of you today. Spend days telling you just how much I've grown to admire Amanda over the last 3.5 years. The relationship between a clerk and a judge is unique and critical. There is no question that Amanda Ward is exceedingly intelligent. There's no question that her legal acumen is next level. What is not so easily measured is someone's confidence. The resilience that they will demonstrate in the midst of a storm. Suffice it to say that in the last year, Dorchester Court didn't simply experience a storm, we weathered a tsunami. And while we have amazing people that were there before, through, and after the storm, I can say without equivocation that the one person that I relied on, without question or pause, was Amanda Ward. She was my rock, my sounding board, my voice of reason, and my problem solver. That same honesty and thoughtfulness that I alluded to earlier was once again on display, but in a way that not only helped me, but more importantly, impacted and benefited the entire court and consequently the community. So how does this translate to this next journey as an associate justice? Again, there's no question that Amanda Ward is brilliant. There's no question that she knows the law, and I can tell you firsthand that she is thoughtful, compassionate, exceedingly hardworking, resilient, caring, humorous, humble, and all business. She takes her work seriously, but still finds time to listen to and thoughtfully address the concerns of others. And while the storm is raging, she is that steady force that pushes back against it and quietly says, actually, I'm the storm. So while I've stated this morning that there's no question about many of her qualities and attributes, I'll close with, there is absolutely no question. Amanda Ward will be an amazing judge and a tremendous addition to the district court. Thank you for your attention.
Do any of the
I'm
council?
happy to answer any questions.
Well, nice to see you.
It's great to see you.
You look great. You haven't changed.
Thank you.
You observed her, so.
Yes.
Can you think of one time that you were so impressed with her in that particular case?
Instead of a particular case, I would really go back to when we worked together in the fall. Particularly in, I'm going to be very sarcastic here. My favorite session, the civil session. I am my most judicial. You would be very proud of me. Councilor Jacobs, you didn't know me then, but you three who voted for me, you would be very proud of me when I'm in the civil session, very judicial. Attorney Kennedy's seen me in the criminal session where I'm a little more loose, but I nod my head. I say, yes, very good. And I hear from the other, what do you say? Very good. Well, I'm going to take this under advisement and I'll issue and render it shortly. Then I go back and I talk to Amanda. What am I doing? She became one of our civil gurus, which is tough because, you know, I've practiced civil for a brief period of time, a couple of years, but you grow so used to criminal. And there are times when we were doing Zoom, which I really do not like. But in the civil session, it's good for the parties. And we would sit next to each other because it was just easier because the camera was right here. And most of the time, if I didn't have the robe on, everybody thought she was the judge, you know, because she was thought, again, she could run the session, which I think is what really translates to this next step in her journey, is the ability to command a session, to be thoughtful, but also to be able to direct people. Because believe it or not, some attorneys don't know how to keep their comments short. And Attorney Ward would be able to help me move that along in a respectful way. So really her presence is just outstanding and she commands the court.
Thank you.
Thank you, Judge. You're doing a great job over there. And just with respect to that issue with civil sessions, you'd agree with me that a lot of judges in the BMC and district court try to lead their way into a criminal session as opposed to a civil session. They sort of like to avoid it a little bit.
I think judges, like most people, are practical, and we also have a good view of things. And civil law is an oxymoron. There's nothing civil about civil attorneys. They're all very,
Because we say that because we need folks like her that have that kind of.
absolutely need folks who love to be in the civil session. And we had the benefit of Justice Bernstein was on recall, and she was doing a lot of our civil, and she was a tremendous resource. So,
Okay, thank you, Judge. Okay, and the next witness is my friend, Assistant Clerk Magistrate Amanda Ward, who I also met when she was a young DA.
Rowan? That's true. I'm Amanda Rowan. Hi, everybody.
I'm sorry, Amanda.
Don't worry about it. We're both Amandas. Both Amandas. Good morning, members of the council. My name is Amanda Rowan, and it is my absolute pleasure to be here to speak on behalf of Amanda Ward and ask that you confirm her as an Associate Justice of the District Court Department of the Trial Court. Amanda and I worked together as Assistant Clerk Magistrates for close to 3 years at the Middlesex Superior Court. Amanda was proficient as both a criminal and civil clerk in Superior Court, which is very rare. She was able to competently assist attorneys and pro se litigants at both the civil and criminal counters, which is unusual. She took pride in her work as an assistant clerk. She took responsibility to educate herself on laws and procedures on both the criminal and civil sides so that she could effectively and competently clerk in any session. She could advise litigants and counsel on both sides. Amanda was always very compassionate and patient with whoever she dealt with in court or at the counter, and she never judged people. We see people going through a difficult time. She treats everybody the same, whether you're a pro se litigant or an attorney or a member of our office staff or a judge. Amanda truly shined in the COVID-19 pandemic. COVID-19 presented the courts with innumerable problems and challenges, and Amanda instantly went into action to find solutions and train her colleagues on their use. I remember coming into work and feeling completely useless. How am I going to conduct these hearings? And Amanda instantly took me by the hand, literally, and showed me how to use Zoom. It was a website none of us had ever used before. She patiently walked me and countless other clerks and judges through how to use Zoom. She showed us how to set up the cameras in the courtrooms. She helped us so that litigants, attorneys, the public, and staff could participate in hearings. Amanda took on the responsibility of keeping our court moving during a very difficult, stressful, and challenging time. In the time I've known Amanda, I have been amazed, not only by her ability and her work ethic, but even more by her strength of character and her kindness. We're gonna be okay. We're gonna get through it. In the 7+ years I've known her, Amanda and I have spent a lot of time both in and out of work, and she has been a true and loyal friend to me through both easy and difficult times. I also know Amanda to be a wonderful mom. We are both mothers to boys. Her son Cameron is a few years older than my Miles, and I often lean on Amanda for advice and guidance on how to handle the challenges that come with raising a child. She has raised a smart, well-rounded, talented, and respectful young man on her own, and for that she deserves endless credit. It's within that context that I'm amazed by her experience and what she's accomplished up to her career at this point. Her resume is remarkable under any circumstances. But considering that she did all those things while raising a child on her own, it is downright awesome. To call Amanda impressive is an understatement. Lastly, Amanda is the rare candidate that can literally get started on her first day. She has spent her entire career preparing for this role at the Suffolk DA's office, as a public defender at CBCS, as an assistant clerk with me at the Superior Court, both civil and criminal, as an assistant clerk magistrate in an extremely busy BMC court, approving and denying search warrants, determining if probable cause exists on new arrests, or presiding over civil trials. The district court needs judges, and it needs judges that can hit the ground running. Amanda's entire professional background, her integrity, her compassion, her strength of character, her honesty, and her dogged work ethic make her an excellent addition to the district court bench, and I wholeheartedly recommend her for that position. And I would be happy to answer any questions if you have any.
Do the councilors have any questions? Thank you. You can leave your application with Dara on the way out.
Thank you.
Okay. Now, we get to the hard part. Is there anybody here in opposition? There was a line out the door. Okay, your turn. It's yours.
Thank you. Good morning, councilors. I want to begin by thanking Governor Healy for nominating me as Associate Justice of the District Court. I also extend my gratitude to Lieutenant Governor Driscoll for her support of my nomination. Thank you to the JNC for considering my application with rigorous due diligence. Immense thank yous to Chief Legal Counsel Paige Scott Reed and Deputy Legal Counsel Dara Kesselheim for their support and assistance, as well as Valerie McCarthy and her team for shepherding me through the process. I extend further thanks to each of the members of the Governor's Council for considering my nomination. I am truly grateful for the extensive time and effort you put into evaluating judicial nominees, and it's been my pleasure to speak with some of you and to be here now to discuss my candidacy. I would also be remiss if I did not thank the Honorable Retired Justice Geraldine Hines, Supreme Judicial Court. Her academic scholarship, influence, mentorship, guidance, advocacy, advice, and patience have been immeasurable. I wish that there was a phrase bigger than thank you to express how deeply I appreciate all that she's done, not just for me, but for all of us in the Commonwealth and beyond. I'd also like to thank the following judges of the Superior, Municipal, and District Courts. Judge Krupp for being a listening ear, an example of judicial excellence, and for being an ally and an advocate. Judge Ellis, who encouraged me to start this process and helped me through it. Retired Judge Bernstein, for coming back to Dorchester and reinstituting its civil litigation session, for your support and for our talks about tennis. Judge Figueroa for charcuterie boards, an empathetic ear, and for taking action when opportunities presented themselves. Judge Fentress for being my friend from Northeastern, Sari in the BMC, and hopefully soon a colleague on the District Court bench. Judge White for being that voice of guidance from my first days in Dorchester up through now and hopefully going forward. And finally, the Honorable Dorchester judges. First, Justice Tynes, Judge Zaganiori, Judge Grant, Judge Reese, she's over there, and Judge Kaplanis for taking me into the Dorchester Court family and for the work that we've done to address the challenges and triumphs of our community court. To my remaining family and friends who I cannot all individually name, but who I have shared joyous times with, as the Golden Girls would say, thank you for being a friend. Thanks to my son Cameron for being such an amazing guy. I love your quiet confidence, your low-key and powerful demeanor. You are smart, emotionally intelligent, kind, respectful, funny, and a cool person. I love you a lot. I did not think I was gonna cry. Love, admiration, and appreciation to my parents. Deborah Ann Ward, here, and Robert Lawrence Ward, my father, who passed away on April 21st, 2015. His photo is here with me. On December 20th, many years ago, when I was 6 months old, my parents adopted me from Boston Children's Center foster care. As they tell the story, my dad had already decided that he wanted to bring home a chocolate brown baby girl. As the two of them were escorted through the foster home, my dad laid eyes on me, immediately picked me up from my crib, held me in his arms. It was love at first sight, and they took me home that day. My mother's birthday was the following day, December 21st, and she always told me that meeting me the day before had been her greatest gift. Every year, our family celebrated birthdays and holidays, but we also celebrated the anniversary of the day that I came home with my parents. I am truly grateful for their love and support throughout my life. And I know that I would not be here today if it weren't for them. I was chosen by the two most amazing parents in the world. Every day, they demonstrated how important that choice was to them. Growing up in Cambridge, my beautiful mother had a career as a teacher and was a lifelong educator. My father was a Vietnam veteran, and upon his return, took a career in the facilities department of Harvard University. My mother is one of the nicest people you will ever meet. Her presence is immediately warm and inviting. She gives the best hugs. Some of you might have got some today. I always feel wonderful when she introduces me as her daughter, which inevitably leads people to look at me and wonder, what would happen to you then? But my personality takes more after my dad. He was cool with people too, but after a breaking in period. My parents doted on me and did everything they could to provide me with the best childhood imaginable. Growing up, people would often ask if I was spoiled. The answer is yes, but not rotten. As a family, we lived a life rich in education, experiences, relationships, and joy. Had I not been selected by the wards on that day, who knows where my life would have been, but I was. And my life has been and still is amazing because of that. Because of them and because of my dogged work determination, I have been able to build a foundation and aspirations to serve as an Associate Justice of the District Court. Growing up, I participated in a lot of sports. As I entered high school and started thinking about career goals, I thought of my extension of love for athletics, which was mainly basketball. And I wanted to pursue medicine and be a sports trainer or some kind of doctor to elite athletes. After taking a few science-based courses, I realized that medicine might not be in my future. So I settled on becoming a lawyer because it was another, albeit very different way to help people. From that moment on in my junior year of high school, all of my academic and professional pursuits were aimed at the goal of going to law school. I chose to go to American University for college, partly because I was still hanging on to hoop dreams and wanted to walk onto the team, but mostly because it was situated in Washington, D.C., and it would give me access to the hub of our government, which felt like a natural first step to pursuing a legal career. After graduating college, I came home and worked in different legal settings like big law private firms, the Attorney General's office, the District Attorney's office, in order to build an understanding of the different fields of practice in the legal community. When I enrolled at Northeastern Law a few years later, I knew that I wanted to use my law degree for a career in public service. During my first 3 co-ops and internship experiences, I worked on cases that allowed me insight and access to the state and federal courts. I worked on the prosecution and defense side of criminal cases. I assisted on civil cases and in civil rights litigation, actions from both the plaintiff and defense side positions. All of those experiences allowed me new, sought-after views on the law. But I noticed a common thread throughout when it came to the people involved in those cases. For many, their appearances in court were primarily because they were facing challenging times in their lives. I also noticed that the district court was one of the first places that people in local communities went for help and for solutions. Whether they were in dispute with a neighbor, facing eviction, subject to wage attachments, civil stuff, debt collection actions, or suffering from substance use disorder or mental health issues, the district court has been a place that can offer resource and guidance to people who are navigating some of the greatest challenges in their lives. My final co-op or internship was with the Committee for Public Counsel Services, CPCS. The agency made me an offer of employment upon my graduation. I was thrilled to have secured a job and to be working in a capacity that would allow me to achieve my goal of using my law degree in service to the public. I was slated to start my employment with CPCS on September 5th, 2006. On September 8th, 2006, my son Cameron was born, and I was not able to begin my career with CPCS as planned. The life plan that I had envisioned after law school was slightly diverted. My new career was placed on hold, leaving me unemployed. I became a newly single person after a long-term relationship ended. I was living completely on my own without a roommate or a partner for the first time in my life. I was learning to be a first-time mother to a newborn child and a newly added member to the bar. During that brief time, as I was unemployed, I needed state services and assistance to make ends meet and to keep my household afloat. When I was finally able to start my employment with CPCS in early 2007, I was able to transition off of the state assistance. The new work-life balance I was dealing with was difficult. Although now employed, finances became overwhelming. My parents did what they could do to help, but still over the next few years, I faced an eviction. My car was repossessed, and I had to take on several jobs to afford the basics like an apartment and a vehicle and to keep my son in daycare. The challenges that I faced during that time were emotionally, socially, and professionally taxing, but also, thankfully, they were fleeting. They were short and temporary because I had a career, a network of distinguished colleagues, mentors, and social support systems of family and friends that stepped in and helped me rebuild and regain footing. Those experiences taught me resilience and the importance of a strong support network, which many individuals unfortunately lack. It also taught me empathy. I lived firsthand some of the same struggles that many of my clients have faced, and that also many of the people who come into the district court face as well. As a lawyer with CPCS, an assistant clerk magistrate, a paralegal in the Attorney General's office, a victim witness advocate, I've worked daily with people who are dealing with chronic, severe, and relentless trauma and loss. As a justice of the district court, it's imperative to realize that every person who appears before the court has a backstory. Acknowledging and making an effort to understand that backstory of each individual is vital to contextualizing their current narrative. For many, their stories might involve abuse, substance use disorders, mental health struggles, developmental adversities, or social challenges, or maybe just hard times. But I would be sure to draw on the knowledge and experience that I've had in my own personal life and in working with such populations to inform my practices on the bench. I would be sure to utilize compassion, empathy, care, and fairness, partnered with the application of the law and the principles of justice to try to achieve results that serve the individual before me and the community at large. The work that occurs in the district court has a direct impact on the people within the neighborhood, its businesses, its schools, its social institutions, and its sense of community. It's my hope that the work that I will do as an associate justice will create positive outcomes, not incomes. Those two, I guess, if you do well, that will reverberate in that respective community and the Commonwealth. Thank you to this honorable council for your time today and for considering a vote in my favor for elevation to the bench as an associate justice of the district court. I welcome your questions.
Councilor Jacob.
Well, good morning. I want to say thank you for coming out and braving the weather on that day. We had a really great broad-ranging discussion on a bunch of areas. And rather than retread any of that, you alluded to it in your statement, and I had already had it written down, so it just sort of circles. But I wanted to hear, given the struggles that you just shared with us, and just in general, what draws you to public service rather than taking your knowledge and experience and going to one of the big corporate firms where you could rake it in hand over fist?
I'm drawn to public service because it's public service, right? I know, but I really want to utilize what I think is an extraordinary opportunity. Who's barred and a lawyer and who has attained a degree of education that many people don't, to use it in a way that can help other people. I would be happy to make millions of dollars, but that doesn't serve anybody other than me. And so I wanted to use the career and my degree to be able to help to serve people. And I think that serving as an associate justice in the district court allows for that public service on a daily basis as you work with individuals and community partners.
I appreciate that. I really do. Is there any area, and I know you're bringing incredible background of experience with you, but is there any area that you foresee you'll have a learning curve?
Yes, all areas. we're you know, as we're I consider that I am constantly learning and evolving. I think, as Amanda said, I would hope that I can hit the ground running to some degree, but now I would be working in a different capacity. And so kind of figuring out how to make the decision versus listen to the decision that's being made, or how to evaluate certain things. I think that will probably be the thing that I'm going to spend the most time on, is how to like thoughtfully consider what's in front of me and make the right decision for all the parties involved.
I appreciate that. From your vantage point, is there any area of the district court where you would like to be a part of seeing a change of some kind? Is there well, I'll leave it there. Is there any change you can foresee wanting to be a part of?
Um, recently, the district court and superior court has instituted, a pilot program for restorative justice. And I think that that is an amazing movement, and I know that it's just beginning, across the different courts. That is something that I would definitely be interested in participating in, because, as you know, it involves, bringing community members in and allowing them to, have time with the offenders in their cases and see if all the parties can be like holistically satisfied with respect to what happened in their cases. I think it's an important movement, and I think it's something that can help kind of move the trial court and the criminal justice process forward. So I think that that's something that I would also be, excited to work on. Also, I work with Amanda Rowan, or I did, on lawyer well-being, and Judge Krupp is interested in that as well. And I think that that is also a really important movement in trial court, to making sure that all practitioners who practice in court, and that includes all the different divisions, have mental, social, professional well-being. It can only advance the practice that we do.
Yeah, I really appreciate that. I don't have any other questions. But, just really more.
Council Devaney.
Nice to see you again.
Nice to see you.
That was really a rush, and I really appreciate you coming out to meet me, because we didn't have too much time much wiggle room to find a time. Obviously you are well respected, and it shows by the people who have come here to support you. I just wanted to ask you, after being here 25 years, I know the council hasn't had many assistant clerk magistrates that have risen to the position of judge. Tell me about that. How are you different? How do you see yourself most qualified to be a judge right now at 43 years old?
Well, I'm 47. So thank you for the time lapse. I'll take that. I think it's the breadth of the experience that I've had. I don't want to bore you all with recounting my resume, but I've done a number of different things in different capacities over time, which I think have all kind of led into this moment. Being an assistant clerk magistrate is an important step, being in Dorchester with Helen and Jonathan and Judge Times, because you see a lot of the things that judges see. And again, you don't do the things that the judges do in the decision-making capacity, but you're able to review and understand and look at case types and things in the way that judges do. So I think that that is a great advantage. Other things that I've done, though, I've taught at, law school, trial practice. So I had to understand like the law and litigation techniques and things like that. I've done, I refereed volleyball for a year or two, but that experience, right, has taught me how to kind of be sharp in decision-making and be able to take a little bit of blowback when things don't go the way that people think that they should go. So I think kind of the overall breadth of the experience, all of the things that I've done over time have led me to the moment.
Well, I think, your life experience, you will have empathy for people who come before you, because you have walked in their shoes. That's important to me. And I first want to say that this hearing is very important, and you see this room full. And I would just like to advise the presiding counselors on these hearings that they do not schedule them for 9 o'clock. There's only 3 of us here, and your hearing is important to us and to all these people. So I hope that this will be the last 9 o'clock. And I thank you for coming, and for all you people getting up early and coming. Your experience has been with outstanding judges. And I have to say this, and it doesn't pertain to you, but I see Judge Bernstein with all these wonderful judges. Here's an example why the age 70 has to change. It's ridiculous. This judge had to quit when she was 70, but she's so qualified to be a recall judge now. Does that make any sense out there? Please change it. So, okay, I'll get off my, all right. But no, I see that you have had experience and you've moved, quite a bit. You were, you started out in a district attorney's office for a year, and then you went to the Attorney General for 2 years, and then you went to, you were paralegal for a year, and then you went to Boston Municipal Court, is that correct after that? Yeah, I think so.
Then I went to law school and then I started with CPC.
Yes, and you went to law school, and then so as a lawyer, you started in Boston Municipal.
Yes.
And you work with good people there. I've been here a long time and I know that. And you went to Roxbury, and tell me, with your experience as an assistant clerk magistrate, what do you see that you would like to do differently than judges that you have observed in your experience through these different positions?
Well, as an assistant clerk magistrate, I served in the Middlesex Superior Court. I sat with Judge Krupp often, so there's nothing that I could change.
Well, you won't tell us.
No, honestly, he is extremely smart. He's diligent. He moves his cases quickly, but like thoughtfully and thorough. Like I learned so much from sitting with Judge Krupp. So nothing that I could change there. And the same in Dorchester. I've just happened to be with an amazing group of judges who know how to administer justice in these courts. Some things, I think that there's always small steps and room for improvement. So maybe should I be elevated to the bench? And I experience things personally, there might be small things that I see that might need a tweak or something new or something a little bit different. But based on all the experiences that I've had to this point, I think that the courts run fairly efficiently, pretty well. And it does depend a lot on the judge that you have on the session. If the judge can do it, then the work gets done.
In meeting with you, when we met for a long time, I felt that if I was going into court, that I would be seeing you smiling. That means a lot. That means a lot, because people are scared when they go into a courtroom, And I just felt you just a regular person, not thinking about judgeships or any of that. And I think you identify with people that come into the court. Now tell me, you work with great judges. I'm not talking about them. I'm not pointing to them. But do you feel there's racial discrimination in our courts?
I think that there are degrees of implicit bias that happen across kind of all spectrums, right? Within the court itself, among the employees that work there, within the practitioners who work with clients or colleagues, sometimes in the way that jurors view defendants, sometimes in the way that judges or clerks view the people that come before them, because it's natural and it's human nature. But I also think that when people do the work, acknowledge it, and do what they can to eradicate it in that moment, or at least make an effort to step that back and figure out where that's coming from, that a good result can be achieved. I don't think there's any overt racism that happens in the court system. I think just as human beings, sometimes we have to figure out how to manage some of the incessant things that can creep into our minds.
Well, for us counselors, we don't have a crystal ball, and we only know the person that's coming before us and what we learn. And sometimes we're let down by what happens. And there is racial discrimination, and I will say it. And I go out to the prisons and I meet with these Black inmates that have been wrongfully sentenced, and it's wrong. And, in my little way, I'm trying, and I've got a wonderful governor who is supporting me in doing this and trying to identify these people in prison and who deserve to be released. But I just was wondering yourself, what will you do? How can you, as a judge, change that whole, what's going on out there in the court? What can you do? I mean, you're one person, but can you have a group? Can you have some way that you can take this up and look into it, into these courts and see?
I think I would start kind of individually, just recognizing where I sit and stand on these issues and how I deal with them and how I address them and do my best to make sure that I'm fair and equitable with the people that are appearing before me. I expect that there are training programs. I expect that there are resources and other programming that is being instituted by the trial court or other agencies that talk about and deal with these issues. I could seek those out, join those programs or, whatever the kind of initiatives are, and work with them.
That's great.
It's always
I've known discrimination. My parents were Italian immigrants that came as children, and they went through horrendous times. My father wasn't allowed to work because he was Italian. I won't go into all that. So I don't, it isn't a major thing like the Jim Crow days, but I know, and I experienced it. And so, it is important to me. What about the specialty courts? Do you get involved in those drug courts, the veterans courts?
Yes, Dorchester has a recovery court, a thriving recovery court, which is headed by Justice Lisa Ann Grant. There was a boat program also in Dorchester. When I was in the Boston Municipal Court, there's the Veterans Court, there's Homeless Court. So yes, I've been participating in a lot of those court programmings. I think that they're extremely important because they get at the core issue of what's happening with that individual when they're referred to that specific court program. So I think it's a great resource for the
Have
district.
you gone to the drug graduations?
I love recovery court graduations,
Fantastic.
mostly because there's food, but also always food and cookies, and there's but it's a really great occasion.
Most emotional
Yeah.
for me to go. I sit in the back and the tears come, no one sees it. But these are people who were addicted for years. They could be 60 years old and older, and they have gone through this program. What a wonderful program. People don't know that there is help out there. And to hear their stories and to hear they're clean and what they've gone on, it is just beautiful. So, so you had a lot of experience, a year here, 2 years there, and everything. When you put it all together and you look back and you're going to be a judge, what do you feel was the most important contribution that you learned in that position to bring to the court? What was the most valuable?
I think the most valuable thing is to treat each individual, to see each individual, right? And to work directly with the person that is in front of you, right? I don't want to make any decisions based on preconceived notions of who that person might be because they happen to be in this group, or a preconceived notion about the type of offense that they committed, so it must mean X or Y. I want to look at the person that's standing in front of me, hear about what's happening with them, as I said in my statement, contextualize what's happening in that moment for them, and to deal with that, and to try to find solution-based outcomes so that they don't come back or appear before me again. I think that that's the lesson that I've learned across all the work that I've done with all of these amazing people in my career.
So in your experience, you have a lot of people come before you as an assistant clerk magistrate. Is there one that you will never forget and it was very rewarding that you had part of that process?
Maybe not as an assistant clerk, but as a lawyer with the Committee for Public Counsel Services. There was a young man who was picking up a series of cases. He was in his late teens, early 20s. And for whatever reason, all of a sudden, he started picking up criminal cases, and I was assigned to his first case. As we were going through the series of his cases, within about a year and a half, he had 7 or 8 cases picked up over that period of time. But because I was able to get a social worker, work with him holistically, figure out what was going on in the background, figure out what he needed at that moment, and to work on setting him up for success in the future. We were able to resolve all those cases. We preserved his record, meaning that he didn't have any convictions on his record at the end of the time. Cases were closed simultaneously at one time, so he wasn't on like a long extended probation. And so by preserving that conviction, if he wanted to, he could go to college, he could apply for financial aid, he could get housing if he needed. So to me, that's a success, right? Like I was able to kind of triage what was happening in that moment, and set the person up for hopefully no further like re-entry and appearances in court.
Dr. Fanny, if you could wrap up, you're a little.
The time, they voted to time us, can you imagine? So, because I asked too many questions. I'm sorry, but, okay, on the reverse side now, when you have, you know, you can only go so far because you weren't a judge. There are some cases that, that really will always stick in your mind that you wish you could have done more, but in your position you couldn't.
I don't mean this to sound the wrong way, but I've always done the best that I can. So I can't think of an instance, I mean, I can think of instances where the result wasn't what I desired.
Right.
But I think that I've always tried to make sure that on my end, I've done everything that I could to get to the result that I was hoping for. It doesn't always work out that way, unfortunately, right? But that's always been my goal. That's my professional and personal desire.
Thank you.
Yeah, but I just want to say, it was such a pleasure.
I love it, Mike, about 2
And I'm
minutes
so
ago.
glad you applied. I'm glad the governor appointed you. So thank you.
How do I know?
Thank you very much, Mr. Chairman. Good to see you.
Do you?
First of all, I was impressed with your witnesses. It's always great to see Judge Tynes. He's doing a fantastic job. You're doing a great job. I was impressed with your presentation as well. It's good to see your family here. I know this is a big day, and all your friends and supporters. Okay, if I say, you said you're going to take them all out to lunch?
Whatever they need.
Let me ask this. How are you going to treat, are you going to treat them any differently, a pro se litigant who comes before you? I assume you're confirmed.
When I was an assistant clerk magistrate, I did a lot of small claims hearings, and many of those people were pro se. My position was always just to make sure that they understood what the process was. And once they had a good understanding of the process, I would then expect them to present their case in the best way that they could. So there is some wiggle room for a pro se litigant in terms of helping them, not helping them, but making sure that they present the best case that's possible for their position. I'm not going to put my thumb on the scale and explain the law to them, do things like that for them, but I am going to account for that I'm dealing with a non-lawyer that's in front of me. But I also want to make sure that they sustain whatever burdens or responsibilities that they have as a litigant in court.
Yeah, that's good, because they got to get, I know you don't like this word, but give them a little break.
Yeah, of course, for sure.
I get it. Now, most of your career has been in the public sector. What are you going to do if, and I'm a big advocate of lawyers, you know, people like Kennedy and other people who, they're all sole practitioners. They don't have 5, 6, 7, 8 lawyers they can turn to. When it comes to a continuance, how liberal, how easy are you going to be to grant a continuance?
I'm going to lean towards granting a continuance if there aren't any circumstances that would keep me from doing that. So if there isn't any like pressing issue that's happening with witnesses or jurors or something like that, if the continuance is agreed to, or if there's no opposition, I would grant the continuance. As I was saying earlier, I believe in lawyer well-being. And so if an attorney is coming before the court and asking for a reason to move that case, if it's a compelling reason, I will allow them to do that.
This is, why does it have to be compelling? You have enough business. Honestly, what is compelling so important? And give me an example of what you would consider compelling.
Well, I think the district courts are busy places, and so it's important to kind of still move cases along. If the attorney and their client both are okay with continuing the case, that makes sense. But if the attorney doesn't come for the court with a reason other than I just don't feel like doing that today. That doesn't feel like an important reason for me to grant a continuance. I think a compelling reason would be if there was a family issue that they needed to take care of, if they scheduled something that was now in conflict with that day's appearance or whatever they were trying to continue. I've always told my supervisees to protect their calendars. It's important. So if they schedule a vacation and they, case got put on while they were supposed to go on vacation, come in and ask for the continuance. That is a compelling reason.
You use the words, I don't know if you mean it, come in. I mean, these lawyers are being charged by their clients, so it's a criminal case. And if they have to come into your court to request a continuance, that's gonna cost the client more money. These lawyers charge a lot of money. I don't go to court anymore. I used to go all the time. Actually, I have one case, but whatever. You expect them, if somebody wants a continuance for whatever reason, assume you think is legitimate, do they have to come in or can they just file a motion?
I think I would follow the practice of the court that I was in. Whatever the first justice's rules are regarding continuances, those are the rules that I would follow. So I know sometimes in Dorchester, there are administrative continuances, and I know sometimes the parties come in. So whatever the rule is in the court that I am in.
There is no procedure. What would you do?
So if there's a written motion, if there's no objection,
So let's make it, those are all easy. When there's no written objections, those are easy.
right?
Those are automatic, on 99%. There is an objection. What, the DA wants to move this case. But you want to come in?
Well, you're saying it's a written motion, but the DA is objecting.
Yes.
Okay.
You want to come in and argue the motion, I guess is my question.
Not necessarily. It would depend on kind of what is in the body of the motion and what the basis of the objection is, if I'm allowed to consider a written motion.
When you said, if you're allowed, are you confusing me? Why would you not be allowed?
So as I said, it would first depend on the practice of the first justice.
No, you know,
There is no practice. Okay.
Practice. All right, you can't be fired.
Fair point. So continuances for everybody. No, I don't. It depends on the circumstance, but as I said in the first instance, I think that it would be likely to grant the continuance. I would lean towards granting the continuance.
Would you want them to appear if the other side was opposing the motion?
I think a written motion would be sufficient. I would not require.
With all due respect, I'm not getting the feeling, just to be totally upfront with you, that you're gonna be lenient when it comes to continuances. That's just my gut feeling. Listen to you talk about procedures of the court. You talk about, I probably would do that. My point is simple. Who cares? Even if it's been on 2 and 3, 4 times. I mean, what's the problem?
My gut feeling is that this is all new to me.
What?
It's all new to me. If I were to be doing this, it would be new to me. So I would definitely want to, it's hard for me right now to bear down on a exact decision, not because I'm not interested in being lenient, not because I'm not interested in being accommodated. It's just because this is something that would be new to me. Something as simple as granting a continuance has never been anything I've done before, right? And so I would just want to make sure that I did everything appropriately. But if I am allowed to, there's no procedure, there's a written motion, there might be an objection, and there's no reason not to, I would likely grant the continuance.
I can tell you this, I ask that question all the time, and I would have to say 99.9999% of the people who sit in that chair, and I don't know if I believe it. Oh, yeah, no problem, 3 or 4 times, no problem.
Got you.
You're on the other side, you're that point, which I'm surprised.
Maybe I think it through too much. Maybe that's the problem, but I'm trying to be thoughtful.
Just on this continuance again. You're going to a certain court, because you don't know where you're gonna sit, and that procedure is, if there was a case and the prior judge, the chief judge in that session, no further continuances. Now so-and-so says, I got a continuance. I just, we'll give a few examples. I just got retained, and the arraignment is today in a case in Somerville District Court. And you've never had this situation, I don't think you have, worked with yourself. And now, you know, when he going to the arraignment, he's probably gonna get paid. He's gotta pay his secretary, he's gotta pay the rent, you know, the electric bill. So he wants to go to that arraignment, because more likely than not, he or she's gonna get paid as an attorney. But there's no further continuances. And it's a larceny case. I don't do criminal, larceny of $500. It's not like some huge case. You're gonna grant that continuance? What are you gonna do on that? Procedure is no further continuance.
Well, in that instance, you said the lawyer was just recently retained and it was scheduled for an arraignment. If they're not going to be ready for the arraignment and they're asking for a continuance, I would grant the continuance.
I mean, what?
I would grant the continuance.
I'll tell you one last story. I had someone sitting in that chair. That's like the only time someone was against continuances. It was a few years back. I said, what happens if, I forget, it was the husband or the wife, has a surprise vacation? It was like their 20th anniversary, wedding anniversary. They're going to, I don't know, Bermuda or something. So he's surprised. I don't know, he or she surprised too. So he filed that motion continuance, and the judge said, your spouse should have known your schedule. And it was like a real hassle to get that continuance. That to me is insane.
I agree with that it's insane.
Okay.
I have a vacation coming up. And,
But just remember one thing, if I could. You know, you seem like a really nice person. I think you're gonna do a great job. But these lawyers who work for themselves, they do have to pay, and it's tough out there. I heard your compelling story. I get it. I get it. I remember when I first did court appointments, way back when. I was in 3 courts at the same day. I'm eating my sandwich in the car to go to the BMC, and I just left Roxbury. And then I gotta go to West Roxbury, because it's tough out there. You gotta pay the rent. So it's tough out there for those sole practitioners. It's not like they work in the DA's office. So they can say, hey, Mary, hey, Joe, can you handle this arraignment on this motion? Because I can't make it. I'm taking a day off. It's hard for them. So I hope you, just if you could, remember that.
I understand and I appreciate that, and I will definitely keep that in mind.
You want to check on that?
Allowed. Motion allowed.
Any further questions? Councilor Kennedy, a huge supporter. Wanted your name submitted by the governor. He called me. I don't know if he called anyone else, but he called me and says, oh, she's a wonderful person. She's so qualified, blah, blah, blah. So again, huge supporter.
It lives in Everett.
Right around the corner from
Don't forget that.
Doesn't that right? I get it.
us.
Good luck.
Thank you so much.
Council Ferrara. Thank you, Mr. Chairman. Your resume is incredible. Like Council Iannella said, Councilor Kennedy's been on us from day one, how eminently qualified you are. He's a huge fan, which means a lot to us. Thank you for your service, for what you've done to, Committee of Public Service, and your job in the trial court. Just one thing in passing, like recently I was in court, and I won't even say the court, but a judge continued a restraining order for another year against my client, who had a security business, so he can't carry a gun, can't work, can't be within 100 yards of his kid, so can't go to the kids' games. And the embassy was something that happened literally, it said 20 years ago. So 20 years ago, she let something happen, I take the kid's cell phone away, and all of a sudden there's a restraining order issued, and then issued for another year. Do you see abuses of restraining orders, and what's your take on that?
Interesting. I think restraining orders are tricky because you have the plaintiff who is expressing an imminent or a fear of the defendant, whatever that is, an imminent fear for their safety or the safety of their children or whatever the issue is. And then obviously you have the defense side where the person may not see or experience the status of the relationship in the same way that the plaintiff does. So I think in evaluating those two different positions, I have to just listen to the information that would be provided to me and then make a determination as to whether or not I believe that the person has a legitimate claim under the law as to whether or not an order should issue. If there is a potential abuse of the order, it doesn't get issued. If there is a legitimate claim by the plaintiff, then I would issue the order. I think that's the only way that I can look at that and determine what should happen.
Yeah, just to put it in perspective, this guy had guns for 20 years, nothing ever happened. He had a restraining order for a year, no incidents whatsoever. And then she comes back and goes, yeah, I'm still in favor from something 20 years ago.
She didn't talk about any additional incidences between the time,
With me, there was 0 incidents.
0 incidences. Did she give a specific reason as to why she felt that she was still in fear of the defendant?
20 years ago, they literally had this map.
Later.
That was it.
I don't want to. My inclination, my thought process, based on the scenario that I have and what I understand the scenario to be, is it would be time to vacate that restraining order.
I just also say you give everyone a fair shake and, consider the ramifications. But I got divorced 20 years ago and thank God there were no restraining orders or anything like that. But the fact that you can't go see your kids' games for 2 years, you can't be within 100 yards, and it's really extremely difficult for this gentleman and to earn money because he was just armed security guy. So it put him out of work and he can't see his kid.
I think,
Huge ramifications, I'm just saying, I hope that judges tailor them as small as possible, and try not to hurt people on the other side.
yeah, I was gonna add that maybe there would be a way to modify the restraint, if the restraining order were to remain, in fact, maybe a way to modify it. But I think, like I said, based on what you've said, at that point, it might have served its purpose if there hadn't been any additional incidences within that time frame.
Thank you. I think you're gonna make a great judge and you have my vote next week.
Appreciate that, thank you.
I'm gonna give you one piece of advice. Don't listen to people like Tynes just because he's the presiding. Hear what he says.
I got it.
You're putting the robe on, you're sitting in the courtroom, you make your own decision. It irks me all the time when I go in front of judges. It happened to Counsel Ferrara and I, we were both in Waltham on a case, and the visiting judges there, and we had to come here. And we needed a date. And he looked at us and said, I'm sorry, the presiding judge's policy, right, Joe?
Yes.
So we had to do a quick jury trial in the morning and still get here by 12. We did, but I just find it absurd that judges, that you're not appointed, you're appointed to handle cases, not to follow arbitrary rules that presidings might put in place. So completely ignore Tynes, with the rest of us do. All the time, huh?
To the BMC, she can continue.
And when I say ignore Tynes, I'm not talking about Marjorie.
Gotcha.
It's for her. All right, we're good.
Mikalen Howe to the associate position of the probate court. I'll read the letter from Governor Haley. I am pleased to nominate Mikalen E. Howe to the position of associate justice of the probate and family court. I submit this nomination for your advice and consent, and I'm enclosing the nominee's resume for your convenience. So welcome, and if you'd like to take a moment, please introduce your guests.
My pleasure.
Thank you.
Go from the right. I'm honored to have Chief Judge John Casey here.
Always a pleasure to have Judge Casey in the room.
My witnesses, Joyce George, Allison Walsh,
Hello.
Judge Paul Cronin from the Bristol Probate and Family,
Judge.
my son Jordan Aylesworth,
Hello.
my husband Tom Aylesworth, my brother Colton McDonald, and father Paul Howe.
Welcome.
Sitting in the governor's chair.
Sitting in the governor's chair.
Would expect nothing less.
I mean, Pat.
I love it.
Right, so what we're gonna do first is we're gonna hear from two people on your behalf. First, we're gonna listen to Joyce George, Assistant Chief Probation Officer. Welcome. You can stand or sit, whatever you're comfortable with.
Okay, I'll sit, I guess.
Thank you.
I'm so thrilled and honored to be here today. I have been a probation officer for 33 years, and I was 22 years in Suffolk and 11 as the assistant chief in Bristol. So I've had the opportunity to meet and work with many judges. My quick list, when I was thinking of what I would say about this wonderful woman today, the good judges that I've met, they have a knowledge of the law. They're able to keep the courtroom in good shape and litigants at bay. The great judges have compassion and kindness, and I think that's so important in what we do. And, they work on the access to justice. The really great judges, which Mikalen is going to be, have compassion, kindness, they have empathy. I see that in her every day, and what makes her over the top is her sense of humor. And I think you need a good sense of humor to do what we do. Her compassion and kindness, though, stand out. I've had the pleasure of working with Attorney Howe since January of '23. We're a very tight group in Fall River down in Bristol, and she fit right in. Her door is always open. Probation has a unique relationship with judges, I think, and we do a lot of work behind the scenes that people don't see all the time. We're always able to go to Mikalen, to Attorney Howe, with questions. In a panic, her demeanor is always calm. She calms us down. I observe her calming the litigants down. People can get, probate court is different, I think, because you're not losing your freedom, you're losing your children, you're losing your paycheck, things like that. So you really need to be able to deal with those people. I've observed the three skills that I talked about, kindness, compassion, and sense of humor every day with Mikalen. I'm so proud to be here because when does probation get a chance to have a say in something so important? And I think we are so important because we have that special relationship with the judge. When we heard that she had the opportunity to come here today, probation was hooray. We were all so happy and proud. And then we realized that she might be leaving us. So I was secretly sent here today to sabotage her efforts.
You can fix that today.
Which I can't do because she is just going to be so fabulous and the people of Massachusetts are going to benefit from her. And again, I couldn't be prouder of her or more excited to have the opportunity to tell you how great she is. Thank you so much.
Thank you. I have a question. So I'm a Bristol County guy. That's why I get to chair the hearing today. Suffolk or Bristol, who's doing a better job?
That's tough. I grew up in Suffolk.
I'm friends with Tom Hoy too.
I grew up in Suffolk and learned how to work really hard there. Bristol is just a place of its own. And what is so great about Bristol is that we all get along. So if you go into the office every day and you're happy to be there and you can laugh with people and it's the joint effort, you're really lucky. So I'm really lucky, and I'm really lucky to have this lady next to me leading our troops.
Thank you. I'm avoiding that question.
Thank you for your service and thank you for coming here today. Where do you live?
I live in Rainham.
Excellent. Glad to have you as a constituent as well.
Yes.
Councilor Devaney, you have a question?
Thank you. So how long have you known this nominee?
I've known her since January of '23.
January 23, so for over a year. Okay. So what have you seen the greatest attribute that she would bring to the court?
I think that she just knows people and she deals with people. She deals with people that are really having the worst day of their lives, and she's able to calm them down. Very good at access to justice. She can go out and she can realize that someone took 3 buses or walked to get there today, or that they don't speak English, and she's able to solve those problems. And she really makes everybody feel okay and calm. And in a crazy courthouse, that's what you need. You need someone that is going to be able to do that and to keep everybody calm. And her demeanor, I could go on and on. She's just really great.
Well, I have to tell you, your testimony means a lot to me, and I've said this before. Sometimes we have someone sitting in that seat and I'll say, how well do you know this person? Have you ever seen them in court? Once, yeah, forget it. You know, that means nothing to me, but you really, and you were sincere, it was heartfelt. So it's a personal and professional relationship, I can see that. So I thank you for coming.
Thank you so
That means
much.
a lot.
Oh, thank you so much for having me.
Thank you very much. Next, we're going to hear from Allison C. Walsh of the Walsh Law Offices in Hingham. Welcome.
Thank you. Good morning, everyone. As the counselor just said, my name is Allison Walsh. I am an attorney in Hingham, and there is no place I would rather be this morning than here to support my colleague, former law partner, and most importantly, friend, Mikalen Howe, in her nomination to the position of Associate Justice of the Probate and Family Court. Like all good Massachusetts friendships, my friendship with Mikalen started over a Dunkin' iced coffee. Nearly 20 years ago, Mikalen and I were both serving as law clerks together at the Brockton Courthouse. Mikalen as the probate and family law clerk, and I as the juvenile court clerk. Back then, there actually was a Dunkin' Donuts in the courthouse parking lot, and on Mikalen's first day, I asked her if she wanted to go with me to get an iced coffee. She agreed, and on our 50-yard walk to Dunkin', a lifelong relationship began. During our terms as law clerks, we had the opportunity to work next to each other day in and day out, and I had the opportunity to observe how the judges in Brockton trusted Mikalen with the most important and sometimes highly publicized cases at that time. Following our tenure as clerks, Mikalen went to work as an associate at Rubin and Rudman in Boston and eventually became a partner there. While Mikalen was at Rubin and Rudman, I had the opportunity to work with her as co-counsel on a complex divorce matter and to work with her on a case in which she represented the trustee and I represented a minor child who was the beneficiary of that trust. We also represented opposing parties in a divorce matter. Having worked both on the same side of a case with Mikalen and on the other side, I can attest to her skill in the courtroom, her ability to work well with all counsel and court staff, and her unsurpassed writing ability. I know if I am filing a brief or an important motion, Mikalen is the first person I ask to review it. Her many red pen revisions have always made my submissions clearer and stronger on behalf of my clients. In 2018, after having left my prior firm to hang my own shingle, I had the opportunity to partner with Mikalen. For 4 years, including through the dark days of COVID, we worked together, both of us practicing domestic relations and Mikalen practicing probate litigation while I also practiced in juvenile court. While I always knew that Mikalen was a great family law attorney, practicing alongside her every day made me appreciate how well-versed she is with the MUPC and other probate regulations and matters. While so many of us as divorce practitioners shy away from probate practice, it is an equally important part of the probate and family court docket. And if Mikalen's nomination is approved, this court will truly benefit from her expertise in that area. It was certainly a loss for me, though a gain for the Commonwealth, when Mikalen decided to leave private practice in 2023 and return to public service as an assistant judicial case manager in Bristol. While there, she has reportedly done great work in streamlining procedures and case management, which has benefited both the judges and local bar and provided litigants greater access to justice. Knowing Mikalen both personally and professionally as well as I do, I can say without hesitation that she has the demeanor necessary to sit as a probate and family court judge. Tensions are never higher than in cases involving people's children, and those are the types of cases that probate court judges hear every day. I know few people who are more well-balanced, thoughtful, and fair than Mikalen. I have been in a number of conference rooms with her when tensions and voices have begun to rise, and she has always done an excellent job of bringing the temperature in the room down, and far more quickly than most would be able to. I trust she will be able to do the same in the courtroom. Lastly, I know that Mikalen will do a great job as a probate and family court judge because in addition to her expertise in the law, she has the lived experience of successfully co-parenting her stepson, Jordan. You can read every law book in the world about co-parenting, but until you have the lived experience of your child telling you at 11:30 p.m. on a school night that they forgot their soccer cleats at the other parent's house and they need to get them before the 6:30 a.m. bus, you do not truly understand the gravity of the orders you are entering for families. As a step-parent myself, I know. I also know that it is Mikalen who, in her wonderful way, encouraged me to take a leap of faith when I was first dating my husband, who had 2 small children, and when I was reticent to become a stepmom myself. If not for Mikalen's encouragement and modeling of her strong relationships with her husband, Tom, and stepson, Jordan, I may not have married my husband and have the family I have today. In short, I cannot recommend Mikalen highly enough for the position of Associate Justice. I am a better person for having come to know her over the past 20 years. I'm so glad that we both needed a Dunkin' iced coffee that day in Brockton in 2005.
Well, thank you. That was very, very touching and very well presented. I'm glad you met Mikalen. Was it Brockton? So I was a law clerk in the Superior Court in Brockton 100 years ago. It was a good place to start, and it's not often that we have 2 law clerks sitting side by each, as they say. So it's very nice of you to come and share your thoughts about the nominee. Any questions or comments, Councilor Devaney?
Nice for you to come. I love it when someone comes and they really know this person personally, as far as professionally, and you fit that bill. What do you see as the greatest attribute in everything you know about her, her personality, her composure, everything? What is she bringing to the bench?
I would say with Mikalen, I think, and I guess I'm, sort of thinking about having worked with her as well. I would say it's her measured approach to things. She's very methodical. She doesn't get rattled. She kind of, will, if there's an issue that's going to be complex, I think she takes a step back, she takes a deep breath, she thinks about it, and then she tactically looks at it in a tactical manner and figures out how she's going to approach it. And I think that's something that, you don't want people shooting from the hip always, at the court. And I think that you won't get that from Mikalen. I think things will be thought out and very well reasoned.
Oh, that's great. I appreciate your testimony. Means a lot because you see her on a daily basis. How often?
Well, for the 4 years that we were partnered, I saw her on a daily basis. When we were law clerks, I saw her on a daily basis. So we were partners for 4 years. We were law clerks together for about 6 months or so, about half of that term. And then the 15 or so years in between, I would say I saw her, I don't know, on average, maybe once a month or so. We get together, we talk on the phone. We were we were close friends and stayed in touch all those years. We had cases together, as I said. So, sometimes I'd see her more frequently. But it's been a constant relationship.
Your testimony means a lot, believe me. And so I'm so glad that you came.
Thank you, Counselor.
Thank you. Anyone else here in favor of the nominee? Cronin, I assume you're here in support?
Absolutely here in support, and I will say that I feel like I'm shooting myself in the foot because she's been a wonderful addition to the Bristol County Probate and Family Court the past year, and she'll be a wonderful judge as well.
You want us to say no? Do you want to keep her?
I would like to keep her, but I think the Commonwealth needs another great judge.
All right. Well, how many years ago were you here?
So I was here 7.5 years ago.
7.5. Well, congratulations. I hear good things about you in Bristol County.
Love to hear that.
Thank you for serving.
That was my good vote.
All right. Anyone in opposition? Check the door there. Leonella? Is there a line out there? Right. All right. Then we'll hear from you, please.
I did introduce everyone. I'd like to first begin by expressing my thanks to Governor Healy and Lieutenant Governor Driscoll for the honor of this nomination as an Associate Justice of the Probate and Family Court and for including me among such a distinguished group of nominees. A thank you to Councilor Ferreira for hosting this hearing and guiding me through the process. And a special thank you to each of the councilors for the time you have devoted to this process and for your consideration of my nomination. It was a privilege to speak with many of you before today's hearing.
I'd also like to thank Valerie McCarthy and her staff for all of their efforts to facilitate this hearing. I'd especially like to thank my witnesses, Joyce George and Allison Walsh. Whatever I have done to be lucky enough to have people say such kind words, I truly appreciate it. And I'd like to thank so many colleagues who have supported me and encouraged me during my practice and through this process. I'd particularly like to thank Judge Paul Cronin here today, with whom I've had the pleasure of working each day in Bristol County, and the other members of the judiciary in the Bristol Probate and Family Court, Judge Field, Judge Jacobs, Judge Moses, and Judge McMahon, who's recently retired. They've been tremendous role models. And I'd also like to thank Judge Francis Giordano, First Justice in Essex. I had the privilege of being an associate working for her, then a colleague, and I'm proud to consider her a friend. Through the application process, I've shared a lot of the granular details of my legal practice and experiences, but I want to take this opportunity in the personal statement to give you a sense of some experiences that have shaped me and which I would draw on if confirmed as an associate justice. You hear from a lot of nominees they knew early on that they wanted to be an attorney and that they followed a direct path to get there. To my parents' chagrin, my route was more of a meander than a straight path. I never imagined having a career as an attorney. After attending Sarah Lawrence College with a concentration in literature, I worked for several years as a bookseller here and in California. In my proudest role before attending law school, I worked in development and fundraising for Blackside Incorporated, then the largest Black-owned film company. Blackside made long-form PBS documentaries about social justice, including the landmark Eyes on the Prize. Blackside told stories about big issues by focusing not on the big names of the movement, but by focusing on people whose names and smaller actions may not be widely known, but had a huge ripple effect in our social fabric. I entered law school with a plan of returning to the world of creative nonprofits. Like so many plans, it changed dramatically. Northeastern's co-op program gave me my first exposure to litigation and to the inside of a courtroom, and I connected immediately. I felt comfortable with and committed to translating a client's story into legal argument. And once I found that touchstone, my path became a more direct route in the law. When I discovered family law, I got to combine that desire to relay a client's stories with a desire to make an immediate difference in clients' lives. Looking back, the real through line of my life is an appreciation for individual stories, not just who the person is, but the what and the why of their experience. It's not surprising that I focused on individual stories when you get to know my parents. My parents are real examples of people who devoted their entire working lives to serving marginalized or vulnerable populations. My father, who's apparently now been made the governor, worked in special education, first as a classroom teacher and then as an administrator for the Boston Public Schools. My mother, who passed away 2 years ago, started her career as a clinical social worker and then spent the last decades of her career in the Boston Public Schools as a pupil adjustment counselor and a truant officer. What my parents did best for us was to model how to be interested in and empathize with people in any circumstances. In their work, they helped children and families by asking questions without judgment and actively listening, even when the answers were uncomfortable. In our own family, I saw my parents, both devoutly Catholic, attend pride parades with my siblings and celebrate their marriages and the birth of grandchildren. And granddogs, I might add. They wanted to know what made us happy, and my parents celebrated that with us in whatever form it came. If I can model their authentic curiosity towards people, then it would be a real achievement. I was lucky to be raised in a supportive family. I know many people don't get that, but my greatest fortune was to meet my husband and form our own family. I introduced Jordan earlier as my son because he is, but in the eyes of the law, I'm a step-parent. As a credit to my husband and Jordan's mother, but especially to Jordan, I was never treated as a step-parent, and I'm fortunate to have had the opportunity to watch him grow up over the last 15 years. If I've been able to teach him anything, I've learned twice that much from him about how important family is and how very little labels matter. Labels just aren't meaningful, particularly in the probate and family court, because a family's trajectory is never static. So many factors can affect and create change. And my family have experienced the impact that mental and physical health issues can have, and know well that today's solution may not be effective in the near and long term. A few years ago, we became acutely aware of how quickly a situation can change in a different way. And I think it's important to share some of that story today because of how it's impacted. My husband was a serious cyclist for decades, and while riding his bicycle, he was hit by a careless driver. The list of his injuries was devastating. You name it, he broke it. While he was hospitalized, we envisioned so many scenarios we never planned for. Today, the three of us sit here and we feel so fortunate. Tom received great support from his firm. I received support for months from my partner, Allison Walsh, and our office manager, Amy Malfoy, and that helped keep my practice going while we juggled months of follow-up medical care and physical therapy. The financial and emotional impact that kind of injury could have on a family without resources is something we have often discussed. All three of us have made some different choices following that accident, knowing that nothing's guaranteed. For me, the accident was the final push to transition from private practice to rejoining the court in the current role I have, something I had long dreamed of doing. I appreciate that every person standing before the Probate and Family Court has a story and a set of experiences that go far beyond the limited issues the court may be addressing that day. My personal experience allows me to have the empathy necessary to consider their circumstances of both litigants and attorneys. And I hope my professional experience allows me to bring stability from a consistent interpretation and application of the law. I thank you for your indulgence with this personal statement, and I hope after consideration that you'll vote to confirm me as an Associate Justice. Thank you.
Thank you. It's a great story you have, and incredible resume. We're going to start with Counsel Devaney.
Nice seeing you again.
Good to see you, Counselor.
Such a rush. We had so many at one time. I thank you for all the time that you afforded me. I know it was hard for you to do that. No, I was very impressed with your resume. You had been in private practice, and then you changed to go into the position of, what is it?
I'm an Assistant Judicial Case Manager.
Okay. So people will understand what that position is. Why don't you explain that and tell us why you made that change?
The role itself, I think the closest analog in a Superior District Court is an Assistant Clerk Magistrate. In the Probate and Family Court, and particularly in Bristol County, it's a very hands-on role, which is why I was intentional about joining Bristol County. So I do a lot of screening of cases, looking at the cases that are on the court's docket. If there's some early intervention that's needed, either to address procedural or substantive issues, I can reach out to counsel and parties and work to resolve that. Another significant part of my job is running Pathways Case Management Conferences, which is an early intervention program to get modification actions that are filed in the Probate and Family Court to be heard quickly and hopefully addressed just as quickly, to both relieve some of the burden on the court's docket, but to also get litigants a result more quickly and efficiently than they might have seen otherwise. For me, I think that you had asked about the decision to return to the court. I had loved being a law clerk. I pride myself on being a good advocate while I was in private practice. But I saw an opportunity to make more of a meaningful impact rather than on a client-by-client basis, but to address things from the court's perspective, and I was excited to do that.
Okay, so you went to the Probate and Family Court in 2004, and you were there 1 year.
Yes, as a law.
And then you chose to go to Reuben in Rudman, and you were there, what did you say, 12 years. Okay. So tell us about this transition and how the decision-making was, because afterwards, after 12 years, you went to Walsh and Howe with your own, and then Bristol probate and family court, and I want you to tell the people what was your duties as an assistant judicial case manager. So, so I'm just looking at a year and then 12 years and then 5. So it's quite you've had quite a background. So tell us about all that, and what do you think you learned the most that will be the most valuable as a judge in all these positions?
Those are some excellent questions. Just to clarify, the transition from my first role with the court into private practice, the law clerk term is 1 year. So there's an expectation that it only lasts for 1 year. There are some clerks who extend for a second year. But I was very excited to get into private practice. I was a little older going to law school and was excited to start in private practice. So I did the 1 year as a clerkship and then moved on as was expected. And then for the next 17 years was in private practice. The transition from a larger firm to a smaller firm, I think, was motivated not for any dissatisfaction with being in a larger firm. It's great to have those resources and to see some of those cases. But I wanted the opportunity to be able to work with some clients who might not be able to afford a larger firm in Boston, and wanted to shape the trajectory of some of my cases independently, and was lucky enough to have the opportunity to partner with Allison Walsh and to do that for several years.
Most rewarding case, looking back.
I think any of the cases that I'd be reluctant to single one of them out. I think the common theme in any of the rewarding cases that I have been is where I felt like families were left in a better position than when I started, either because through the use of the courts, we were able to come up with some systems and orders that helped them function better as a family, or because through the litigation process, we're actually able to open up some communication and dialogue. It's certainly what I like most in my current role too, through the Pathways Case Management Conferences, is you're bringing people together who may agree on nothing, and in the span of an hour or two can resolve an entire case.
So looking at all of these positions you had, what is the most meaningful experience that you've had that you'll bring to the court as a judge?
That's a great question. I think the most meaningful experience has been getting to work one-on-one with individual clients and now with individual parties to see the difference that the work of the court makes in their lives. And it can be easy in the probate and family court to be a little flip about an issue that somebody raises, because we hear the stories about people fighting over odds and ends and pieces of personal property that don't have a significant monetary value. But as you do this work and work with people, you learn to understand if it's important to you, then it's important to be addressed. And I'd hope to be able to do that.
I'm going to interrupt this because I have been asking time and time again that people see who's speaking, and no one sees who the councils are that are speaking. They only see you. And yet at our public assembly, all the councils are shown when they're speaking. I've never gone to a committee where they don't show the person speaking. I get calls all the time, and I want to say it publicly. I can't do anything about it. I keep asking because they ask me why. There's no reason. So I'm saying that again, please show the person speaking. It is not fair to the public. Okay, said that, I'm sorry. But when did you decide that, I'm ready to be a judge? Because you've had the experience before. Tell me why at this time. You said this is the time.
I have thought about it for several years. It's a daunting task, to be sure, and it takes a little hubris to say I think I could take it on. When I joined the probate and family court, saw more of the behind the scenes day-to-day work of judges, in particular Judge Cronin, but all of the judges in how they managed their dockets and how they prepared for their cases. In the amount of thought and that went into it, I found it incredibly engaging, and I knew that it was a challenge I wanted to take on. and was committed to doing it. Timing wise for my family, this seems like the best time to do it now. And I hadn't considered doing it, before.
So you've been a lawyer, how many years now you've been practicing?
Since 2004.
Okay, so things have changed, our society has changed. How does that affect the court and how does that affect you? Being in the court, representing people, what are the changes that you have seen? I mean, the family, everything has changed. So how did that change you in your practices?
I don't know that I agree that everything has changed. What I think has happened is that people have become a little more open-minded and taken less of a narrow view. For instance, in the time that I have been practicing, I've seen parties and judges really move away from an expectation that one parent would be a primary physical custodian. When I started practicing, we referred to visitation time for parents. And I can't remember the last time anyone's used that language now. So I think that if there's been a change, it's that there's been an opening of an approach in how the court is viewing litigants.
Well, I'm going to ask you something from the experience I've had here. And this was one of the first year I was elected to this office. And I read this in the paper, and I'm going to pass it on to you and ask you what you would have done. There was a judge which she wasn't on that long, but anyway, from the probate court. And she was asked by a client to be allowed to go across the state, across the country, it was Oregon, with her fellows and to live there with them. And she had been divorced. The husband had been loving the father. He lived near there and he used to see the children almost every day. He would even go there the night before Christmas to be there in the morning, to see them when they woke up. So he was devoted. So she had no one in Oregon. There was no family member, there was no friend, there was no occupation, there was no job waiting for her. And tell me how you would have ruled. Would you have allowed her to leave Massachusetts and go across the country with these children?
I think it's almost impossible to predict a ruling without really seeing the facts of the case or hearing evidence. Removal cases are absolutely some of the most difficult things that the court sees or that as an attorney, we have to litigate. I had a few in practice and there truly is no winning.
This was before you and she wants to go across the country. How would you rule? And also, I have to say that she ruled, and they don't say visitation, I hate that word, visitation to this devoted father, 1 hour on the computer with his children. You can't hug the computer. So he literally was divorced from his children. And I believe strongly that every child should have equal rights to their mother and father. And you have a family setting, no matter what the circumstances are, if they are good parents, they deserve that relationship with that child.
I absolutely agree with you that the role and involvement of parents should be respected.
So that's really it. There's nothing more to add to that. There was nothing more. She knew no one there. And to me, it was, I think it was cruel. And it was obvious that she just wanted to take his rights away from him as a father. And that's all you could see. There's nothing more to add to this. It was before you. She wanted to go someplace where she didn't have any job, didn't know anyone, and to take them away from a relationship with their father. And you don't know how you would rule. You need more information.
I think it's absolutely important. But if the facts are defined solely as you're describing them, that does not match up with the standard that the law would require me to apply.
Well, it went into newspaper, the Boston newspapers. I've been here 25 years. I don't see that they, see someone that has acted in that way. And I think of that father, shame. they took away his ability to be a father. And, you know, I believe in joint custody. I believe in, you know, a child should have relationship with mother and father. If they're good people, they don't deserve anything less. So I'm kind of disappointed that you didn't jump on that, but that's okay. So have you had removals?
I have, in practice, I have represented a parent who wanted to remove, and I've represented a parent who did not want, the other parent and child to move. So I've been on both sides of the case.
Council Devaney, that's, your time is exceeded.
You know what? This is so outrageous that we're timed.
Okay.
I think that every council should have the ability to ask a question and be able to answer all questions. Time. Want to get out of here fast, and so that's me.
In the meantime, thank you. I want to introduce my esteemed former governor's councilor, Representative Carol Fiola.
Questions? Okay.
Councilor Representative Fiola, welcome back to the governor's council chamber.
Can't answer more on this.
Excuse me. Not only is she your neighbor, friend, but she and I go way back. She sat right over there for a number of
A
years.
decade she sat here, a decade.
Great memories,
I'm still here.
and I see things have not changed, so enjoy, good luck to you, and thank you for letting me do this.
Here, Representative.
Ken,
Thanks, Representative. You're always welcome. Thank you. Councilor Iannella.
thank you very much. Good to see you. You know how important family is to you. I heard that. Now, I think you said, read somewhere, you live in Kingston. Ways though, how far is that? 10 minutes, 20 minutes, an hour?
About an hour.
Family's important to you, right?
Absolutely.
Family comes, there's a case comes before you. You got two minor children. Let's say 10 and 8. One lives in one spouse lives in Fall River, the other spouse lives in Kingston. By all accounts, both parents are great parents. Okay? But they disagree on, and I don't know the terminology, I don't do probate. They disagree on visitation, custody, whatever the terminology is. See, there's more factors involved. They go to school, let's say Kingston. What are you gonna do in that when it comes to, again, it's not the right, I don't know what word you use, but visitation. They can't agree. Each parent wants them to be with me all the time, or you all the time. What are you gonna do? Let's say they live 40 minutes away, make it a little easier. 10 minus.
I think one thing to always be mindful of is that some of these schedules really involve and impact children who the court never hears from. We hope that the adults can manage a schedule and manage pickup and drop-offs, because ideally, you want for both parents to be involved and have as much parenting time as they can have. Distance is difficult, but distance is also a reality. Sometimes we have folks who live only a few miles apart, but because one is in Boston and one is north of Boston, it takes the same hour. It's a difficult but real fact of life that sometimes the parents do have to drive or manage a schedule to accommodate that. But I think and hope that they will be able to do that so that both could continue to exercise, equal parenting time if it's possible.
All due respect, you didn't really answer my question. You're gonna make the decision. These parents, they love the kids. They love their two kids. They want to spend all the time, each one of them, with the children. 100%, 100%, maybe I'll give you a little bonus here. What are you gonna do? 40 minutes away. What are you gonna do? You have 2 minors, 8 and 10. They can't agree, but they are fantastic parents. They can do anything because there's no financial constraints. All up to you. Give me a sense where you're coming from.
If you've got two great parents and there's no constraints on them, that makes for an ideal situation to have shared parenting time. And then you look at, is there a way that that can happen so that those children can get the benefit of both parents? And that's what I'm gonna look to do.
I'll make it easy. Would you give them 50-50? 50-50 means this to me. There's 7 days in a week. There's 31 days in a month. Are you giving them 50-50? You know, when you say shared, I don't know what that means. That could be 18-12. I'm trying to nail this down. Are you gonna?
I think if you've got two great parents who want to be involved and are able to make that work, I'm looking to 50-50 as the starting point there.
Okay, you would rule that way, even though both of them want 80-20. You'd say, you know what, I'm going 50-50.
If that's in the best interest of the child,
I
absolutely.
do appreciate that, because I knew 2 kids and 2 parents. Parents were decent people. One parent lived in Jamaica Plain, the other Hingham. That's 40 minutes away. And you know what that judge did? That judge had courage. 50-50, right down the middle, right down the middle. Whether it was the summer vacations, this and this, you know what? Those 2 kids today, one is a lawyer and one is a businessman. They are doing phenomenally. They are super kids. So it can be done. And I think in that situation, they had a guardian ad litem, and they had an attorney for the child. So there were 2 people. So I hope, remember that, because I wrote down when you said how important family was to you. So I hope you remember that, because it's important when kids are home and the parent wants to read a book, brush their teeth, watch a movie, watch a sporting event. If the kids are at someone's house, 80% of the time, it's not fair. It's not fair to the kids, forget the parents, because it's all about the kids, and I'm really passionate towards children. I never ask any questions about financial, pay more support. It's not about that. So my point is, it can be done. There's nothing you can't do if you want to do it. And always think of your stepchild when you make those rulings, if you could. I'm not telling you what to do, but family is so important to me. Yes. Let me ask this question. When you have temporary orders, really beef with temporary orders is, and I know the probate court is jam-packed with, you're so busy, I get that. But you're making a huge decision. Who are the kids gonna be with? You got what, 15 minutes aside? You gotta decide financials, I don't care about that, but who's Johnny and Mary gonna be with this? That's a short period of time. What's your thought on that?
I think it's hard because you're right. You have as a judge, you have a limited window of time and opportunity. People, you're not getting all the evidence that you get at trial. The important things to remember, those orders are temporary. So if circumstances change, the order itself can change. Be kind of devil's advocate about it. I have been really gratified in practice to see temporary orders work for the benefit of a parent who may have been the parent who didn't stay at home. So they may have had less of the hands-on parenting role, and through implementing more parenting time in a temporary order, both parents got to see that they were good at it. And both parents could work towards something that they might not have if they hadn't tried out that parenting time through a temporary order. So there are definitely limitations, but also benefits.
Sure. One thing, again, like I said, I don't go to court anymore. I shouldn't say never, once in a great deal. By appointing either a guardian ad litem or an attorney, that seems to me would be very helpful. Again, I know the financial aspect, who's gonna pay for the guardian? You can't have that in every case, but if possible, it seems to me that the guardian ad litem can speak with both parents, can speak with the children, and they're gonna have more than 15 minutes. It would guide you in making your decisions. What is your feeling about a guardian ad litem? That a lot. I don't know much about attorney for the children, but I'm going to both of those.
you're preaching to the choir, because I volunteered with the Attorneys Representing Children program, and would accept it, as did my former partner. We would accept appointments through that. In practical experience, it tends to work better with older children who are more able to articulate what their preferences are. But it's an excellent opportunity for the court to hear from a child without that child needing to be dragged into the process. So I can't say enough great things about that. It's a volunteer program. The bar is very involved and committed to doing it. I hope to see more of that, but I think it's an excellent tool. Likewise, the guardian ad litem, it's an opportunity to hear from a neutral party, providing some information that the court may not have the time or resources to get.
And I don't want to say a lot, but I'm sure there's some circumstances where you don't need volunteers. Between the two parents, there's money to pay for it. You can always explore that. I don't have any further questions. I gotta tell you, really fortunate to work under the leadership of Chief Justice John Casey. He's not done a great job. He's done a phenomenal job. I can only say the nicest things about him. He's a super individual and he's doing a great job in the probate and family court. So I think you're really fortunate. If you're confirmed here, you're working under his leadership.
I would agree with you. We hated losing him as a trial judge, but the court overall has benefited immensely.
And my last thing, your counselor here, Counselor Ferrara, once your name came before us, he called me. He said, you're a super individual. You're going to be fair. You're going to give everyone a fair shake. Big supporter. And when your name comes before us, I think it's going to be in 2 weeks. You can count on my support.
Thank you, Counselor.
Thank you, Counselor. Counselor Kennedy.
So to count the example that Councilor Iannella gave about that couple, I happen to know the father very well, and he's a very, very dedicated father and a very decent individual, and the perfect example of why that should happen. We spoke on the phone, the conversation, and I already told you that your counselor twisted my arm and beat me up about it. I'm kind of in a box anyway because of that. But I have a couple of issues I have, and Judge Casey knows them well. And I agree with Counselor Iannella, he's way above average, at least a solid C+.
My school record. So.
We're all graded on a curve here.
Great chief, the probate court couldn't have a better chief. But the complaint, I don't go to probate court. I never go to probate court. I hope I never do, because if I do, it's because I'm in trouble. But I get a lot of complaints about the probate court. The two complaints I get, and one probably not fair, and I talked a little bit about it, is that there's a perception at least that judges tend to have a bias, either for one side or the other. Sometimes it's a bias for the wife, sometimes it's a bias for the husband. Marriage, not what there's a perception that a lot of probate court judges seem to have a bias one way or the other. Do you think that's true, that at least the perception's out there?
I'm happy to say that in practice, I didn't experience that. I am aware, and I've heard from clients that would say, I've heard this, I've heard, dads won't get this or mothers won't get that. I didn't experience that in practice, and certainly in the last 2 years on the other side of things from the court side, have never seen that. And I hope that's something that gets out more to the public, because I want them to have that confidence.
Yes, certainly a perception. I agree with that.
I agree.
How do we fix that? Because it affects the court, it affects the public view of the court. Obviously, that's very important, that people who walk in the door think they're going to get a fair and impartial hearing before a judge, right?
I agree. On the most practical side of that, I think doing the work of the court day to day and allowing people to see that up close is the most helpful thing. Change does not always come as quickly as you'd like, and changing a perception may not either. Likewise, think that programs like the Pathways Case Management Conference can be incredibly helpful. It's giving parties a chance to see and interact in the court process in a different way than they may have experienced. And I've been really pleased to see how litigants have reacted to it. It's mostly pro se parties, but counsel can also be involved. And I hope that that gives them a different experience, and that in turn, they help people, because that's really how the perception is made and changed, I think, through the litigants.
The other complaint I get, and I really do hear these from people, and Judge Casey has informed me recently that making some changes that they're calling the Kennedy section now, apparently, is that they don't finish trials. You start a trial in August and say, okay, we can't finish this today. I'll see you in November, right? That's generally what happens.
Ideally, it does not happen, but it's certainly true that it does happen.
Now, you're sitting there, you're a judge, and you're trying to decide this case. I mean, you're assessing credibility. One of the main things the judge does. You're also taking in testimony to determine whether it's financial or custody issue, whatever it is. You're trying to figure it all out. You break in the middle of it. You've spent an hour with that person. You've done 500 cases in between, and now we're back in November. You're not going to remember it, right? Most likely. Fair to say?
I think it's fair to say you have to go back and either, as the judge,
Same thing.
or as an attorney, you're re-preparing.
It's not the same thing. It's not the same thing as seeing somebody, watching them be cross-examined, assessing their credibility, and then making decisions. Looking at notes 2 or 3 months later when you don't remember them. It could be some things like facial expressions. It could be all the things we look at when we assess someone's credibility. It could be tone. You're not going to remember all that. And now you're basing it on notes. Do you think that's fair to anybody?
I don't think it's the goal. Ideally, you can get trial dates that are closer together. I think it's both, it's a benefit on both sides.
Why closer together? Why don't we do what we do in criminal cases? Why don't we start a trial and finish a trial and make a decision? I don't see any reason why you can't do that in the probate court. It makes no sense to me at all that you break up trials like that. If I walk into Suffolk Superior Court right now and I start a trial, the other things that are on during that time get pushed back. But you finish that trial. I don't understand why that can't be done.
You do, and I've practiced in Superior Court, so I've experienced that schedule. The practical reality of the probate court is that it's a different animal. And you may have 50 cases on a day.
I understand that, but.
They need immediate attention too, or emergency issues.
Sure, so we go 9 to 1, 9 to 1, 9 to 1, and we address the other issues at 2. I get that the probate court was understaffed in terms of the number of judges you have. Hopefully that's been addressed with the additional judges that they added to a certain extent, okay? And that becomes less of an issue, that the caseload goes down a little bit. And with the vacancies getting filled, the caseload goes down a little bit. If you go, I don't care if you go 9 to 11, but just continue it every day till it's done. It makes no sense to me.
I think you get a lot of supporters for the Kennedy session.
Anyway, as I told you, your counsel is a big. We had a very nice talk on the phone the other day. I probably talked too much because I was sitting by my pool. I'm going to be voting for you next week, and I'm going to be happy to. I think you're going to be a great.
Thank you, Counselor.
Thank you, Counselor. Counselor Jacobs.
Good to see you.
Good to see you again.
I want to start by saying I am always so appreciative of the long drive to come out and see me, and the time that you gave for us to sit and get to know each other and to delve into so many different areas that we discussed. Rather than repeat what we've already talked about, I wanted to hear your viewpoints Particularly, I don't know if statistics are, static statewide. I would imagine there's fluctuation depending regional courts have, a different makeup. But my first curiosity is around the percentage of self-represented that you see in the courts that you serve.
In Bristol County, the last statistic I saw was in the high 70% for cases of being pro se. In my personal experience, that number feels like it might even be a little bit low.
That's so the number I've heard in Western Mass is even higher. But that's why I didn't want to make assumptions that it was consistent everywhere. And I don't know if you have statistics to draw on or just your perception. I'm interested in the proportion of self-represented who are across the aisle from a represented applicant.
It's a great.
Where it's unbalanced.
That's a great question. I do not see that as much. I don't have a statistic to give you. In my practical experience, the cases, I don't see that as much. It does tend to divide pretty sharply that both parties are represented or both parties are pro se. I don't see as many cases where only one party has an attorney. There certainly are. And I think it's a help to the court when there is an attorney involved in a case, but I don't see nearly as many where only one party is represented.
So it's interesting, so I need to do it more, but I have visited courts, and I've seen a couple of instances there where the reason I'm asking about it is it seemed to me in observing that it almost reflected deeper issues that were also at play. It almost was a characterization of imbalance in other ways, in those cases that I did get the opportunity to watch. Which leads me to a couple of areas that I'd just like to hear your thoughts. Do you think there's merit in the idea of in like with district and superior in having a public provided representation in the probate and family court for those who can't afford a lawyer?
I think it's a really interesting idea because I think the parties are well served by having representation. We're dealing with some very complex legal standards and issues. I think it's a lot to expect a pro se party to be able to understand and adequately represent themselves. There certainly are a lot of instances where counsel is available and appointed for folks. I'm thinking particularly of guardianship matters, matters where your right to parent a child may be implicated there. I think it would be great if that was able to be expanded so that more parties had the option for representation if that's what they chose.
Well, would you say there's a bias in when there is a lawyer versus a self-represented in outcomes in terms of successful outcomes being affected by whether or not there's equal representation across the aisle?
So I make sure I understand your question correctly. So that the bias would be in favor of the represented party.
Right. Well, more effective representation, right? Because you've got a lawyer who this is their area of expertise versus self-represented. Does that play out in seeing outcomes that are lopsided?
Again, it's my anecdotal experience and nothing in terms of empirical data, but I don't experience that to be the case. I have not seen that. Certainly, have seen some trials where one party is pro se, the other party is represented, and you don't see a result that is sharply divided in favor of the represented party.
Some of these questions are also just about the situation itself, but also as almost as a reflection of other abuses that show up in probate and family court, financial abuse being one, right? Sort of a mechanism or as part of coercive control and can be reflected in the one side possibly, you know, using financial abuse to have somebody else, another spouse, and I don't want to even gender it because it can go either way. But what are your thoughts around your experience in being able to observe when there is a coercive control situation happening in a relationship, and what as a judge one can do to ensure the court is not used as a further tool?
Great question and a really important one. I think that the probate and family court sees it in the financial setting in a lot of ways, and sometimes purely in the use of litigation tactics, which are physically bringing parties together over and over again, which does go hand in hand with financial tactics. I think it's really critical for judges to look at the patterns of cases and to be mindful of that. It's a difficult thing because on the one hand, if it's in the case of, you know, abusive litigation, you have a party who has a right to file pleadings and a right to try their case in the way they want to. On the other hand, if that is being used in an abusive or vexatious manner against another party, I think that's something the judge also needs to be mindful of. I have seen judges manage that tension by controlling their docket and saying, rather than having repetitive hearings week after week, we're going to put all of those, can file your motions, we're going to have them heard at one time, and take some other approaches like that to help minimize it. But I think it's really from being mindful of the big picture of the case and seeing a pattern of behavior.
Do you feel like you would have that awareness to pay attention to things like that, to perceive it when it's happening? Is that something that you feel like you've got the experience and you've got the awareness around that? It would be top of mind for you to pay attention?
I think it would absolutely be top of mind. I think I've got the experience to address it and deal with it. It was certainly something that I looked out for a lot in private practice, and tried some different tactics and techniques to help manage that for my client if we were on the receiving end of it.
I appreciate that. The last one is, again, I'd like your thoughts around it. It comes from my own just observations and perceptions about what, you know, the broad, what's going on and not necessarily case related, but impact from a human standpoint, impacting experience across the family. What are your thoughts about daycare through the courts for those who are appearing, but also those who are working in the courts? And this, I'll just give you a little why this is actually both in probate and family court and in housing court. We saw younger parents struggling, but definitely distracted by, you know, having their literally kids in arms while advocating for themselves, in some cases unrepresented. And the ability to, as a self-represented litigant for whatever, to focus when distracted by, you know, a mewling, squirming baby or toddler who wants whatever they want, has got to limit their ability to represent themselves to the best of their, but then also seeing sometimes when outcomes didn't go their way, you know, upset parents grabbing kids and marching out just seemed like their day was already not great and was not gonna be a great next few hours with a dysregulated parent storming out, dragging a toddler behind them. That's where the thought comes to for me, that that's a solution, but I want to hear from you, from your standpoint, working in the courts, what your perception is on whether that would.
It's a really interesting question, and I think the tension and the issue that you're spotting and thinking about is certainly something that the probate court experiences in real life. To the extent whenever possible, or not into the courtroom, but if you have parents who show up with infants and toddlers, it's certainly something that we've seen. Ideally, cases can be rescheduled to allow for, to have childcare, not able to meet it, children get sick. There are things that need to be taken into account. It's really the ideal. In the most lawyerly thing I may ever say, I have concerns about the court taking on an actual child care role and being responsible for that. However, it's really important that our court recognizes parents have real demands put upon them. And we may not be able to schedule things and run things. People with families and certain demands that need to be met.
Well, and just to add to that, there's a level of privilege to having childcare available to, from a financial standpoint. When we have, definitely in my region, there's large segment of our population that just literally doesn't have the resources, the funds, or support system in place. And literally, if their kids are not with them, their kids are left alone somewhere even less ideal, just the reality of their existence. There just isn't an option available to them that isn't unsafe.
It would be great if there was a way of supporting that.
I could go on at length on various little tangents, but I'm gonna wrap there and just say thank you for all of your time and I appreciate all of your answers.
Thank you.
Thank you. First, I haven't heard a lot talked about it, but your resume is spectacular. The amount of times that you've been to the appeals court, you've set precedent in cases. You've been an all-star volunteer and a tireless worker on behalf of your clients. Super impressed with your resume. We don't always get resumes like that for the probate and family court. You're very special in that. Couple things. I know the chief has heard this a few times from me, but the worst day of my life was when a probate and family court judge was yelling at me. I was just becoming the police chief. And after we went through a guardian ad litem and me and my ex each wanted custody of the children, he was yelling and screaming that joint physical custody never works and we shouldn't be pushing for that. And that's what the GAL actually suggested. And it worked. It worked wonderfully. I ended up buying a house, 2 houses away from them as well. But they're now 25, 30, and 33, 3 girls. They're the best kids ever. And it worked excellent. So I just want to congratulate you on having that frame of mind. And I'm glad that society, maybe as a whole, I don't know if it's just Massachusetts, but has evolved that 2 equally fit parents should share physical custody of their children. So I'm very happy about that. I had a question about, so like last year I was on a trip. We were in Portugal and Spain, and I had the pleasure of having my good friend Denise Scolanti sitting right behind me. And for a week I heard all these horror stories about divorce. And I'm like, why do you want to get married anymore? So tell me about prenups and antenups. How are those holding up in Massachusetts?
I think they're holding up well. I did a number of them in practice. I would always laugh because the first thing that a client would ask is, did you get a prenup? So that was funny. I said, no, I married another lawyer. A prenup. I think they hold up well. I think that there's, again, a perception that they're really only for people with a lot of assets or a lot of money. And I don't think that's necessarily the case. I think parties are almost always better served by resolving their issues between each other. And so if you can use a prenup or an antenup as a way to do that, I think it's a tremendously effective tool.
Yeah, so I agree with the council's talked about it. The most calls we get about complaints from the probate family court, everyone thinks they get screwed at the family court, right? Do you agree with that? A lot of unhappy people?
There are a lot of unhappy people, a lot of clients who say, thank you for all of your good work. I hope I never see you again.
Yeah, I haven't wanted to go back in 25 years myself. But are there resources? So I get asked frequently, people that don't have means, for a free lawyer. said I got, this, that, with other thing. Are there resources in a probate court for anyone to get a free lawyer? I think it's 70% of indigent cases or
So
percent cases.
couple of different options and opportunities. There is a limited assistance program which allows for people to employ a lawyer for rather than the entire scope of a case, but literally to hire for a particular event or a particular need. If you need a pleading drafted, lawyers who've been certified to work in that program can do that or appear for a particular hearing. I think that can be very successful. Also, almost every county has resumed to having a pretty robust lawyer for the day program where they have members of the bar in that county volunteering their time. Some counties expanded to keep it by Zoom post-COVID. Some have returned to having people actually in the courthouse to participate. It's not the same as having your own lawyer, but if it's for some advice about how do I get my complaint served or how do I answer a complaint, I think it's a great resource to have. The other thing that we're very excited about in Bristol County is having a court service center. That'll be opening in Bristol County, hopefully end of the summer, early.
What is that? What is that?
So that's going to serve as a resource center with actual staff there, attorneys and non-attorney staff helping litigants from district probate and family housing court to be there as a resource, either to send down from a courtroom if there's a particular issue, or they can come in and seek legal advice for what they need to do. Again, it's not the same as having your own advocate, but I think it's a great resource for having trained folks who are working in that courthouse help litigants to marshal some resources and figure out how to approach the case.
I think the chief told me about 2,000 cases per judge right now, which is astonishing. I don't know how you get everything done in a day, but I am thankful for people like you and Judge Cronin and the chief here for wanting to do this job, which is extremely difficult. I think you have the most difficult job of all the courts of Massachusetts by far. So I thank you for your service. I think you're going to be a great judge. From what I hear today, I'm pretty sure you're going to get the votes next week or the week after. So thank you again, and this hearing is concluded.
Much.
At 12:06, and I'd like to recognize Counselor Kennedy for a prayer and for leading us in the Pledge of Allegiance.
I ask that we all take a moment of silence for all the people suffering in wars throughout the world, and remember the people that hopefully someday that some of those issues will be resolved and there'll be peace throughout the world.
Pledge allegiance.
Flag of the United States of America, to the republic for which it stands,
One nation.
Under
under
God.
God, indivisible, with liberty and justice for all.
For all.
I'd like to recognize Counselor Jacobs for a motion to record advice and consent for the financial warrant. Is there a second?
Second.
Motion's been seconded. All those in favor?
Aye.
Opposed?
It's the warrant.
Yes.
Yes, have.
Lieutenant Governor, I'd like to speak on the warrant.
Counselor Devaney, we just voted on it, Counselor, but I'll allow you to offer some.
Thank you. That was fast. I didn't have a chance to second. Well, I just wanted to add that the council received a letter, and it's from the controller, and he has advised us that the Office of the Mass Health Office has told us that the Medicaid appropriation has been exhausted. And so we are asked to vote to allow this addition with this letter, because it is mandatory on behalf of these recipients who are entitled to these benefits. So it will be coming up in their budget hearing to vote and signed by the governor. But I'm asking the council to ask for this appropriation in addition to the other appropriations. Thank you.
So I believe we just
We
made
voted on it.
the motion that incorporated this into
Thank
it.
you very much.
Okay, fantastic. I'd now like to recognize Counselor DiPaolo for a motion to record advice and consent for the pending list of notaries public and justices of the peace. And is there a second? Seconded by Counselor Ferreira. Any discussion? Seeing none. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Ferreira for a motion to record advice and consent for the appointment of Frederick DeCubelis to the position of Associate Justice of the District Court.
With extreme pleasure that I make that motion, Governor.
And is there a second?
Second.
Seconded by Counselor Inella. Under discussion, Counselor Devaney.
I just want to say, outstanding. Really, he covers both criminal, civil. He's the whole ball of wax, and I'm just so pleased that he applied, and he was so accommodating because this was so fast coming through. And I just want to say that I thank him for applying, and I thank you and the governor for bringing him forward.
Thank you, Counselor Devaney. Counselor Ferreira?
It is my pleasure to concur with my colleague, Councilor Devaney. An extraordinary nomination. So I want to thank you, the governor, and your whole team for nominating Mr. DeCubelis. He's a clerk magistrate. He's been an outstanding lawyer in the region. There is everyone in the area of Fall River, New Bedford, super excited that he's going to use his skills, his diligence, his empathy, and he's just an incredible guy, and you're not going to be disappointed. So thank you so much on behalf of the people from Southeastern Mass for nominating Mr. DeCubelis.
Any other comments? Seeing none, I'd ask for the roll call to be called.
Counselor Jacobs? Yes. Counselor Ferrara?
Yes.
Counselor Devaney?
Yes.
Counselor Inella?
Yes.
Counselor Kennedy?
Yes.
Counselor DiPaolo?
Yes. 6 members voting, 6 in the affirmative, the matter carries. I'd now like to recognize Counselor Kennedy for a motion to record advice and consent for the appointment of Jessica Dubin to the position of Associate Justice of the Probate and Family Court.
So move, Governor.
Second.
Is there a second? Seconded by Counselor Inella. Under discussion, if there is any. Jessica Dubin? Seeing none, I would ask the Secretary to please call the roll.
Counselor Ferrara?
Yes.
Counselor Devaney?
Yes.
Counselor Inella?
Yes.
Counselor Kennedy?
Yes.
Counselor DiPaolo?
Yes.
Counselor Jacobs? Yes.
6 members voting, 6 in the affirmative, the matter carries. And next, I'd like to recognize Counselor Devaney for a motion to record advice and consent for the appointment of Carla Salvucci to the position of Associate Justice of the Probate and Family
I am
Court.
very honored to put her name in nomination.
Let me just get a second. Is there a second?
Okay.
Seconded out by Counselor Inella. Under discussion, Counselor Devaney.
Really, in my tenure, I've never seen anyone that's so sincere, so down to earth. You felt like you were with a friend. And I know that people going into the court will feel that way, to see this person just smile. She's gone through a lot in her life. She's gone through some really challenges in her health, and she's fine now, and we're very happy about that. And I can't say enough about her. She has enough experience, criminal and civil, and thank you for appointing her, and I'm pleased to make that motion.
Perfect. Motion's been made and seconded. Any other comments? Seeing none, I'd ask the secretary to please call the roll.
Haney?
Yes.
President Howe?
Yes.
Kathy Kennedy?
Yes.
Kathy DiPaolo? Kathy Jacobs? No. Kathy Ferrari?
Yes.
6 members voting, 5 in the affirmative, 1 in the negative. The matter carries. Next up, we have before us an appointment to the Office of Public Administrator. I'd like to recognize Counselor Jacobs for a motion to record advice and consent for the appointment of Mary Penny to the position of Public Administrator for Hampshire County.
I'll make that motion.
Second.
It's been made, seconded by Counselor Kennedy. Any discussion? Seeing none, there's no roll call necessary for this, so all those in favor? Any opposed? The ayes have it. And I think the only other thing I want to make sure is that everyone's had a chance to meet Sophia Samuels, our intern who is working in the Governor's Council. She's a third-year student at Georgetown University and will be with us all summer. So Sophia Samuels. Yeah,
Nice to meet you.
I think that's it. I'll entertain a motion to adjourn. Okay. Motion made by Counselor DiPaolo, seconded by Counselor Ferrer. All those in favor, all those opposed, the ayes have it.
Good job, as always.
I'll wait till everyone's here to introduce the council. Usually I start with that, but I'll wait till the seats are full. But why don't I give you an opportunity to tell us who you've brought with you today?
Good afternoon, everyone. I'll start that way. My son Malcolm, my daughter Eva, my husband Zach.
Do they know they have to call you Dorado? Now on?
They might speak against my confirmation. Hold them back. My mother, Rice Flanders, and next to her is our dear family friend, Nirmal Nepal. Judge Beth Crawford is one of my witnesses, and Fitzgerald is one of my witnesses, and First Justice Sandman is here as a support person.
Wonderful. All right, and we see the chief has joined us again today. I'm going to start off. I'm just going to read the letter, the nomination letter, for everyone to hear. It's a lovely thing. So, dear councilors, I'm pleased to nominate Alexandra S. Flanders to the position of Associate Justice of the Probate and Family Court. I submit this nomination for the advice and consent of the Executive Council, and enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy, our governor. So congratulations on your nomination. I will just, I don't know when they're going to join us, but I'll introduce the council members who are present, and as they come in, I'll introduce them as they come. I'm going to start. We have Councillor Petito Devani, we have Councillor Kennedy, and Councillor DiPaolo. And with that, I'm going to call up your first witness to give a statement, and you can either choose to stand and give it or sit, whatever makes you most comfortable. But first we have the Honorable Judge Crawford.
Thank you. Should I sit here or?
Right there, you can sit there, if you want to sit.
Please, I'll sit if that's okay. That's where the witnesses sit. Great, thank you. Hello, my name is Beth Crawford. I'm a retired probate and family court judge, and I was Alexa Flanders' supervisor. She worked for me in the Franklin Probate and Family Court. I retired in 2021. I just want to start by saying that I've written many letters of support and have testified on behalf of other people in this position. And Attorney Flanders, I have to say, is by far the most qualified person that I've ever recommended. She possesses all of the qualities that we want in a judge. I think that's really the most important piece. She has one of the sharpest legal minds that I've known, and she's incredibly compassionate and passionate about her work. I want to start by saying that a lot of the work of a probate and family court judge involves separating the legal issues from the emotional issues that are involved in family relationships changing. This is especially true with self-represented litigants, and as I'm sure you're aware, we handle a lot of those in the probate and family court. Attorney Flanders has already had experience in doing this and doing it marvelously. She conducts the initial hearings in cases at the Probate and Family Court in Greenfield. They're called case management conferences. So the families come before her, she meets with them, she analyzes the legal issues and gives them a roadmap for resolving their case. She takes a calm, problem-solving approach, which is just what's needed in this situation. Families come away with a better understanding of what to expect and how to present their case to the court. I have no doubt that this is what she will do as judge as well. I have to say that she was incredibly helpful to me when I was on the bench. She was always there to meet with me to talk about complex legal issues that would arise. I would take a recess, get off the bench and say, where is Alexa? I need help with this complicated jurisdictional issue. Greenfield was right on the border of Vermont and New Hampshire. We had a lot of those complicated issues. Alexa would drop everything she was doing to help me figure it out and gave me wonderful advice and direction. I also want to share that she has amazing writing skills and wrote many of the orders and opinions for me. She writes in a way that's really easy to understand. She doesn't use jargon. She explains the application of the law and explains the court's reasoning. I think this is really important because it gives litigants an understanding of why the decision was made and gives them faith in our court system. I'm sure she'll continue to do just this as a judge. The things that make her remarkable are her patience, her compassion, and her humility. This is clear when you see her dealing with both attorneys and with self-represented litigants. She grew up in a poor community and has spent her career working to help those who are less fortunate. She understands multi-generational effects of trauma, how poverty, food scarcity, and housing insecurity affect those lives of the people who come before the court. These are the qualities that we want in all of our judges. She and I have worked closely together on many projects. We both arrived at the Greenfield Court at the height of the opioid crisis. We were overwhelmed by the number of cases that we had, custody cases, involving substance use disorder. We worked closely together to create the first family drug court in Massachusetts. Attorney Flanders drafted all of the paperwork for the program, including the handbook for it. The program later received a $2.1 million federal grant, and that allowed us to expand to the juvenile court. Attorney Flanders quickly learned about the juvenile court and oversaw the expansion of the program, including working closely with CPCS and DCF to draft the documents. As a result of all of her work, she has great experience and knowledge of substance use disorder that I think will serve her very well on the bench. She was also indispensable in helping create procedures to help the court operate more efficiently. She worked closely with both our registry office and our probation office to create procedures that would make things move more smoothly to better serve our litigants. The court is a model of efficiency thanks to the things that she was able to put in place. She's been an active member of the local bar association, and she served in an important role as a liaison between the bar association and the court. She understands that attorneys who practiced in our court are in more than one court and often in more than one county, and she developed scheduling procedures to make it work for both them and for the court. She was also responsible for the management of all of the estates and trusts in Greenfield. I absolutely relied upon her to advise me on these cases. The bar relies upon her as well. She freely gives advice, helping attorneys who may be handling an estate for the very first time. I could go on and on and on about Alexa, but I'm going to stop here. I just want to say that I have no doubt that she's going to meet the needs of a busy court while at the same time administering justice fairly, competently, and compassionately. She's going to be an exceptional judge who will make all of us very proud. Thank you.
Thank you. I just wanted to introduce, has joined us, Councilor Ferrara is also
Good afternoon.
today. Let me start with a question.
You're retired?
I'm retired. Retired
Retired, Judge.
2021.
Retired early, obviously.
Did. My husband retired, and I'll tell you, I spent 3 years watching him retire. He was having way too much fun, so
Put an end to that?
put him to work is what I did.
That's how I took it. Western Mass you live in?
We live in Haydenville, which is a little town outside Northampton, middle of nowhere. We live in the woods.
Since you managed to come to the East Coast, have you managed to see the ocean yet?
Oh, absolutely. We spent our time on the Cape in the summer.
All right.
Spent a lot of time there.
I have to tell you, thank you for your service. Congratulations on your retirement. I don't go to probate court. I've been practicing law for 40 years, but I was smart enough to avoid probate. I have to tell you, I spent a long time on the phone with the nominee the other day, and I was very, very impressed. She certainly qualified. Next week. I won't be able to stay for the whole hearing, unfortunately. I have a meeting I have to go to, but I think it says a lot that people have come here to support her, driving all that way, and that your testimony means a lot, having given you a prior experience.
Thank you. And I mean it when I say she'll make you proud.
Good. Councilor,
Before I ask the judge, I just want to say, take Councilor Kennedy out of order before me because he has another appointment, I guess.
It's not an order, Marilyn. We're just answering questions. We don't have.
No, I'm asking when we ask the nominee. No, we're asking when it's time to ask the nominee. That's fine. Welcome. When did you come before us? I'm trying to think.
The end of 2011, early 2012.
Imagine that.
Yeah.
Well, you look fantastic.
Thank you.
I think that's what happens when you.
Well, in fairness, I thought the same thing.
Don't look any older than when you came before me.
Oh, thank
I'm
you.
so proud to vote for you. And you beat me to the punch to leave before 7. Because I was going to say that I'm trying to find someone to change that 70. And you are the poster child. Really. So anyway, but thank you for coming. Now, you know, you observed her all this time. What do you see? I mean, she worked with tell us exactly, what was the role she played with the Bar Association and in the court? What did she do that was so impressive to you?
Well, the problems that we had, it's a small community, it's a very small bar. And attorneys could only make a living by practicing in a lot of courts. They didn't just practice in the probate and family court. And of course, if every case was scheduled for the same time, they would get stuck in the probate and family court. So she really would work with the bar to see if we could special schedule cases, or if we could schedule those, take the self-represented litigants' cases at 9, hear those cases at 11, so they could finish their arraignments in the district court. So she was constantly involved in the communication, and she understood what it meant for those attorneys who needed to make a living, frankly, and needed to be in other places.
Go another sort of path. Well, thank you for explaining that, because a lot of people don't know exactly, you know, what her position was and all of the things she did do. So she really had a lot of different responsibilities.
She sure did. She ran the backside of the court. She really did, and helped me on the front side. You know, when I had questions, she was there to help me with it. There's no question. She's had tons of experience.
Well, it was such an honor for you to come for her today.
Oh, it means a lot to me.
I hope you're enjoying it, you and your husband.
Oh, yeah, we're having a wonderful time. We really are. Lots of fun.
That's great. Thank you.
Thank you. Thank you. Thanks, Judge. Thanks for being here. So I have a state rep friend who'll go unnamed, but her husband had a great line I'll never forget. He said, I'm like, how's it going? And he said, it's going good. He said, I got 3 things at work: my motorcycle, my boat, and my wife. I was wondering, your husband wants you to retire.
You know, let me just say, he's fishing on the vineyard right now.
Okay. So thank you for your service. Thank you for coming. You know, I've read through the materials. Interesting career that she's had, because she did a lot of criminal defense first. And I'm sure that's very helpful in the probate court. But has only practiced outside of being a trial court employee for 6 years. Is that correct?
I believe so. Yes, I believe so.
So are you familiar with the trial experience?
You know, I have not seen her try a case, but I can tell you that she would certainly help me with complicated evidentiary issues. If something came up, you know, a child hearsay statement, those sorts of questions, I could get off the bench and talk with her about that, or she may flag those issues in advance for me so that I would be prepared for them, because she had oftentimes done the case management conference, so she knew what to expect. So although I haven't seen her try the cases, she certainly has a firm grasp of the rules of evidence. And I can imagine that her courtroom demeanor will be just like it is when I see her dealing with the public, dealing with the bar, calm, collected. She is incredibly bright and she knows the answers, but she's also a really good teacher and really good at explaining things. And that's how I really see her on the bench. I see her as being able to really help people understand what's happening in the case, what the issues are in their cases. So I think that she will be very good at overseeing trials.
Great. So we have utmost respect for the chief and admire all of you for what you do, because I think it's the most difficult court in Massachusetts by far. The most complaints we get is about the probate court. Everyone leaves probate court unhappy, I think. But we want to make sure we have good people there. So you being here today is a great asset to her. And my question is, so the chief tells me about 2,000 cases per judge. Is that the same like out in Western Mass?
It's a lot of cases per judge. You know, I don't remember off the top of my head what our number of filings was per year.
You know, it's impossible to try that many cases. So that's where you have to really manage those cases, is to figure out, can some of those go to mediation? Can some of these be settled? What will those look like? And that's one of the things that Attorney Flanders really did in these case management conferences, is she would be talking to the parties about mediation. Is that a possibility? What are the issues that are unresolved in your case? Is it a custody issue? You know, is it a financial issue? What do you think? You know, mediation is voluntary, but we had a vibrant mediation program and a conciliation program in the court. So I think it's really trying to move some of those cases off the trial track to the extent that you can by helping people see what the issues are and see how to resolve those. I mean, sometimes they're resolved through counsel when there are a few issues. But so many times, you know, the emotions are running so high, you know, in family changes, you know, whether that's a death, whether it's a divorce, the emotions are so high. And that's the really hard piece of being a probate and family court judge, is really kind of lowering the emotions. I think that's where Attorney Flanders is going to be incredibly good because of her demeanor.
So I have to say this at every probate family court hearing. The worst day of my life was I was before a judge 20-some years ago who was yelling and screaming that joint physical custody never worked.
Sorry.
And I gotta tell you, the outcome has been great. I have a 25, 30, or 33-year-old daughters, and it worked out fantastic. So I'm glad to see that things have evolved. And I'm sure the nominee agrees that shared physical custody should be the norm, everything else equal. And I thank you for your service, and I thank you for your service as well. Thank you.
Any other questions? Thank you so much. I really appreciate it. All right, next I'd like to call up Attorney Fitzgerald.
Hi. Good afternoon. My name is Ann Fitzgerald, and I'm here today to offer my unqualified support for the nomination of Alexa Flanders. I want to start by thanking you for the opportunity to be here today and for the work that you do. It's your hard work that really makes sure that our courts are led not just by qualified judges who are legally qualified, but judges who are good people, who listen well, are compassionate, and are practical. So I have no doubts about Alexa's legal qualifications, some of which Judge Crawford touched upon. So I'm going to talk about who Alexa is as a person and why that person is going to be a really good judge. So I first met Alexa 10 years ago when 4 months after I was graduated from law school, I started at the Probate and Family Court as a law clerk. And from the first, I was struck by how everybody within the court turned to her for help. For the past 7 years, I've worked on a daily basis with Alexa at the Franklin Division of the Probate and Family Court, first as a sessions clerk and now in my role as assistant judicial case manager. Our offices are next door to each other, and so from my office next door to hers, I see and hear a revolving parade of people who seek out her guidance each and every day. Registry staff and probation officers stop by to ask her legal or questions about procedure. She fields phone calls from lawyers, from litigants, members of the public, and the court service center. And the judge seeks her out to talk through complicated issues. I am consistently impressed with Alexa's ability to summon patience and empathy in maddening circumstances. She responds to the escalating frustrations of others calmly. She actively listens to the problem. She asks clarifying questions, and then she communicates about next steps in plain language. The thing I admire maybe the most about Alexa is that not only is she willing to admit when she doesn't know something, she will then work with dogged persistence to find out the answer. And additionally, when something could be done better, Alexa is always willing to reconsider a longstanding practice. Alexa has taught me to step back and to recognize and embrace the complexity of the work that we do. She has coached me through how to respond when tensions run high. She has let me exploit her encyclopedic knowledge of trusts and estates. And she has given me both the opportunity and the support to take the lead on projects. On a personal level, after my mom died in 2019, Alexa, I'm gonna joke up, Alexa welcomed me into her. Promised myself I wouldn't do that. She has made sure that I haven't spent a major holiday alone since. We've bonded over dog walks and gardening, we've celebrated birthdays and accomplishments, and we've shared life's challenges. Over the past 10 years, I have had both the opportunity and the privilege of working very closely with almost a dozen judges. And with those very close relationships, the humanity of each of those judges becomes clear. The qualities that I admire most about those judges, that they are attentive and observant, patient and kind, smart and quick, are all qualities that I know Alexa possesses. So for those reasons and more, I think I would urge you all to confirm her nomination. She will make an exceptional judge. Very kind. Thank you.
We're lucky to have you as a friend.
I keep saying to her, this is a great thing for the Commonwealth. It is a personal loss. My job is going to be legit harder.
You can say no.
I mean,
People would just say no.
she's a good enough friend. I don't think you should do that. That might destroy the friendship.
Selflessness. We all, thank you.
Thank you.
Very much appreciate what you shared. Does anyone have any questions? Do you have any questions? No? All right, well, thank you so much.
Thank you.
Yeah. All right, is there anyone else here who would like to speak in support? Seeing none, is anyone here come to speak in opposition? Excellent, seeing none. I turn it over to you, Alexa Flanders, please share your statement with us.
Thank you. I'd like to begin by thanking Governor Healy and Lieutenant Governor Driscoll for nominating me. Thank you to Paige Scott Reed and Derek Kesselheim for all of your assistance. Thank you to the Judicial Nominating Commission. Thank you to Valerie McCarthy, I saw her a minute ago. Oh, there she is, and the Governor's Council staff. Thank you to my witnesses. Thank you to Judge Sandman, Judge Casey, and DCA DeCenzo for being here. And thank you to all of you. I so appreciate the care and thoughtfulness that you bring to your important work. I want to thank my friends and family, my mother, husband, and children who are here with me today, and also the family and friends supporting me from other places, including my brother in Maine, my father in Texas, and my in-laws in California. I'm so grateful for their support and encouragement. I'd like to tell you a little bit about what matters to me and what has shaped my career. I grew up observing and hearing about my parents' work to improve their communities and the lives of others. Before I was born, my parents lived in Honduras, where my father worked with institutionalized mentally ill patients and my mother worked in a children's hospital. They returned to the United States, where my dad finished college, and I was born shortly after that. When I was 9 months old, we moved to the town of Orange, a former mill town where industry was beginning to leave, a process which accelerated throughout my childhood. My father taught at a nearby minimum security prison camp for a time. My mother was hired to staff the local office of our state representative, and she first made inroads into her new community by helping people with their problems. Although in my early childhood we did not have a lot of money, I loved growing up with goats, chickens, a pig, and a huge vegetable garden. We were part of a vibrant group of people drawn to the beauty of Western Massachusetts, including a large gay and lesbian community. In thinking about the formative experiences that shaped my identity and the values that I would bring to the bench if confirmed, there are two events that stand out. The first is my parents' separation when I was 8 years old and my brother 4. My father moved to the West Coast, where he would go on to enroll in graduate school. Overnight, my mother was a single parent to 2 young children. She'd been working part-time and had recently begun a graduate program herself, which she left and scrambled to find work to make ends meet. She did anything necessary, including baling hay for a nearby farmer. Her courage and determination in the face of very challenging circumstances have provided a lifelong example of persistence and grit, and I am so proud to be her daughter. I've seen the challenges of family transition firsthand, both the economic impact on our daily lives and the emotional impact, as I well recall the sadness and bewilderment my brother and I felt. But I have also been part of family resilience. Our family was loved and supported by our extended community of friends. Family friends made us meals, made us laugh, and our uncles and aunties helped to broaden our horizons. We started new holiday traditions, some of which continue to this day. In spite of, or perhaps to some extent because of these early challenges, my brother and I have thrived. We've both had successful careers in helping professions where compassion is a key ingredient. I've had a 25-year career in law, and my brother is a skilled emergency room nurse. We are devoted parents, partners, and children. And my parents have shown one another kindness and compassion, and today they are close friends who speak on the phone every week. What I would bring to the bench from my personal experience is empathy for all parties involved in family transition, and the understanding that while families may change, it is possible for all parties to thrive. The second seismic event that shaped me was the AIDS epidemic. In the 1980s, when I was a teenager, a number of our close family friends and broader acquaintances became ill with AIDS at a time when there was no cure. I saw how much homophobia and the stigma associated with AIDS affected our friends, and this infuriated me. I graduated from college interested in pursuing public service work of some kind and moved to New York City. I did volunteer work with Gay Men's Health Crisis, raising money for AIDS research. I got hired as a paralegal and became involved in the firm's pro bono work. One project provided wills and other documents for patients with AIDS at St. Vincent's Hospital, which was in the West Village, the epicenter of the AIDS crisis in New York City. For the 2 years that I worked at the firm, once or twice a week, I traveled to the hospital and met with patients who were months or weeks away from death to gather the information necessary for attorneys to draft their estate planning documents. It was intimate, intense work. I was privileged to hear people's experiences, the stigma they may have faced because of their illness, the desperation they felt to protect the families they had created. I was the face of legal help for those patients, and it was of vital importance that I treated them with dignity, with respect, and with compassion, and I have carried those values every step of my working life. My work with this pro bono project made me feel that being a lawyer was a way to pursue my interest in public service, and I decided to apply to law school. I spent the first chapter of my legal career as a New York City public defender, where I gained invaluable experience by being in court every day, managing a high caseload, and doing every aspect of representation from arraignment through trial. I also learned the role that trauma plays for people involved in the court system, long before I had ever heard of the Adverse Childhood Events Survey. As I got to know my clients, I was struck by how often their backgrounds included traumatic experiences. I also noted how often their involvement in the criminal justice system was a result of untreated substance use disorder or mental illness. After we had our first child, my husband and I decided to leave New York, and we moved back to Franklin County in 2006. My husband left his job at a global news service to become a freelance journalist, and I went into private practice. In 2008, our second child was born. Without colleagues to cover my cases, I juggled my obligations in court, appointments, and childcare. In those years, my husband and I were at our desks every night after the kids were asleep. I focused much of my practice on probates and estates, as well as appellate work, honing my ability to think rigorously and write clearly. In 2013, I joined the staff of the Probate and Family Court. One of the things I love about the Probate and Family Court is that our court addresses the issues that matter the very most to people: the creation of their families through adoption, their contact with their children in divorce and custody cases, caring for loved ones with developmental disabilities or other incapacities through guardianships, and handling the estates of deceased parents. The Probate and Family Court may be the only court that many people experience, and how they are treated will shape their opinion of the judiciary. Since 2016, the Franklin Division has run a family treatment court, offering assistance to parents with substance use disorder and seeking to destigmatize their illness. I have observed the cycle of intergenerational trauma and feel that the court can play an important role in helping break that cycle. Our staff meet people where they are without judgment or condescension and impartially assist people in navigating the court process. Sometimes that means being faced with people's fears, frustrations, and anger, understanding that people may come to court in crisis. If I am confirmed, I will strive to be open-minded and curious and to avoid bias, stereotypes, and assumptions. I will focus on the parties before me with attention and care, and will extend courtesy, respect, and compassion to all parties, lawyers, and staff. Thank you for your time, and I look forward to answering your questions.
Thank you. I'm gonna, is Terry left?
Sorry?
Do you think it's Terry left?
He left.
Okay, then, we don't have to worry, just go in order. So I'm gonna start with Counselor Ferrara, if you have any questions.
Thank you. Just about trial experience. Tell me about that.
So I was a full-time public defender from, I started in 1999 and was admitted to the bar in 2000 until I went out on leave in 2004. So I was in court every day conducting many trials in New York City Criminal Court and in Supreme Court, which is the Superior Court equivalent in New York City. So I got a lot of trial chops back then. And then when we moved to Massachusetts and I worked here, I was a bar advocate for about 2 years. So I was doing kind of daily court work, and then I switched my practice more to appellate work, but I still appeared quite regularly in Superior Court with respect to new motions for new trial. And I did some administrative agency reviews under, I think it's 30A, if I'm remembering correctly, those reviews. So I had quite a lot of court experience between 2000 and 2013 when I joined the staff of the Probate and Family Court. And in my role, as Judge Crawford mentioned, now that I'm on the other side, no longer appearing as an advocate, I do quite a lot of helping judges prepare for trial, fleshing out issues that might come up, doing a deep dive on evidentiary issues if, that can be anticipated prior to trial, and then offering kind of behind the scenes, discussion points if something comes up unexpectedly during a trial. So I feel quite comfortable in my ability to proceed.
Have you tried any cases in Massachusetts probate court?
I have not tried a case in the probate court. My practice was more on the probate side of things. So I probated many estates. I negotiated a lot of settlements of estates, did adoptions, name changes, things on the probate side, but I did not do domestic relations trial practice.
What percent of cases get tried in the probate court in Western Mass, would you say?
I'm sorry, what did you?
What percent of the cases get tried?
I think it's less than 10. I would guess that it's 5%.
5%?
I think that's
Above standard?
yes.
I don't practice that, I'm asking.
The vast majority of cases settle, the overwhelming majority of
They
cases.
have to, otherwise the system would be worse than it is, right?
That's certainly true.
Yeah.
I think that's right. I mean, I've never felt that there's anything coercive about the impetus to settle, which I think there is sometimes in some courts. People feel like they have to settle or they're not going to get a fair hearing, and I don't think that's the case in the probate court. But I think there's a fair amount of research that says that if people come to their own resolutions, they're generally happier with the outcome. So in that way, I think if people can reach their own agreement, that's ideal. If it's truly voluntary and it works for them, and then the court is here when people can't reach agreement. But nobody knows their family better than they do, right? So no matter how much time a judge spends with people, we're never going to know, or judges are never going to know the families as well. So if we can help people reach their own resolutions in a non-coercive way, that's ideal.
Have you been involved with any change so that the person paying after 18 years old, let's say there's one child, divorced parents, kid goes off to college. Have you seen any recent changes over the last 5 or 10 years where the person paying gets to pay direct dollars to the person going to school? So say the kid's at school for 40 weeks a year and they're not necessarily paying the other spouse, but some of the money's going directly to the children, or the payer gets some kind of credit for the money going to tuition or something like that.
So I have a couple of things that come to my mind about that. I've certainly seen where parties agree to something like, the payor will give the support directly to the child or pay the child's rent in an off-campus apartment or things like that, or, pay a certain formula towards their books and extracurriculars. I think that's somewhat common. I think if someone is paying child support and or college expenses, the judge needs to take all of those factors into consideration. So I think what I certainly think, based on the Kavanaugh case, I don't know if you're familiar with it, came out, it had a huge impact on our court about 1.5 years or 2 years ago, that really the Supreme Judicial Court was really telling judges to look very carefully at families, not apply a formulaic approach, and sort of hear what, look at the individual circumstances of families. So if it's appropriate to give someone a credit, because they're paying X, Y, and Z, they're paying a cell phone bill and car insurance and whatever else it might be, that the judge should take those things into account and really look carefully at a family and not apply any sort of a cookie cutter approach.
So one of my things that I ask nominees sometimes is, if you're married, no one from the government can ever tell you to pay for your child's education, ever. I'm divorced. I'm lucky I could do it, and I wanted to pay for my child's education. I did it voluntarily. But do you think that there's some kind of equal protection argument or anything, the government telling you because you're divorced, you must pay for your kid's education?
Well, I think it's certainly an interesting issue you raise, and I think there are ways that we could look at the ways that we treat married and unmarried families differently, and there's some discrepancies, right, in the way that things are in the legislation. But with respect to college expenses, it is discretionary. So certainly judges have the discretion to look at what folks' income and ability to pay is, look at the circumstances of the family. It's not mandatory. And so I think judges hear everyone's side of things. The new child support guidelines do have a cap so that unless the judge finds a clear ability to exceed 50% of tuition at UMass, that's the presumptive cap that can be paid. But all of that is predicated on an ability to pay. Certainly for a lot of the folks in the Franklin Probate and Family Court, they couldn't pay that. And so, you know, obviously judges need to be really sensitive and thoughtful about what are the circumstances of this particular family when they're making an order like that.
I didn't know that rule, so you're the first one to tell me about that. So it's 50% of the tuition at UMass?
Correct. That is
That's a norm?
the presumptive cap actually in the child support guidelines. And if a judge is going to do something different than that, there's actually a form. We're very good about doing it, Chief Casey, where you have to indicate the reasons that you're exceeding that. And so specifically a judge would have to find based on, you know, one parent's $400,000 income, or I'm making that number up, they have the ability to pay more than that.
Yeah, no, like I said, I'm a big advocate of education. I'm glad I could pay. But in the background, I have like a problem with the government saying you must pay just because you got the status of being divorced. Because if you're not divorced, you don't have to pay anything, right? If you have a kid, you don't have to pay anything. But if you're divorced, all of a sudden the government tells you must pay. So I just I've thought about that a lot and always ask the nominees. Thank you.
Thank you. Moving over to Councilor Devani for your questions.
Nice to see you again.
Good to see you as well.
I just want you to know, and the other two that came before me, that you are in the Hall of Fame for the Belgian waffle with, with Judge Island, Justice Hines, and people. So that's your accolade today.
Very good.
First of all, I want to ask you about, you said you haven't gone to the probate court, but you have drafted judgments. So, okay, one of the cases that really caught my eye, and I'm wondering how often this happens, that there was a case that there was a man who was questioning the whether this baby, he was the father of this baby, and there was another man whose name was on the birth certificate. Now, it was supposed to be resolved in March 2023, so it's well over a year now. And can you tell us what happened and explain it?
So interestingly, there was a case that was filed a little over a year, about 2 years after the child was born. And so the mother actually was the plaintiff. And so she named as the defendants the person who was on the birth certificate and the person who she now had come to suspect might actually be the biological parent.
Excuse me to interrupt, but could you tell the public, how did you get involved in this, in your position? Because you said you don't go into the probate, so tell us how that happened.
So I didn't try cases as a lawyer. I wouldn't have tried that kind of a case in probate court, but in my current role, I would be one of the first staff people on the judicial side that those families met with to talk about the legal issues that were presented in that case, because they were actually pretty complex in that case. There is a law in Chapter 209C that says that when paternity has been established by signing a voluntary acknowledgement of parentage, which typically takes place in the hospital, that can only be rescinded for a 60-day period after it is signed. And then after that, only for the subject to challenge only for a year on the basis of fraud or, you know, limited categories. And so we were well after that year period. So early on, I recognized that that would be an issue of the application of that section of the statute would be an issue in this case. And you know, how would that happen? Would there be an opportunity to challenge parentage? This case was unusual in the fact that the alleged biological father was objecting to having genetic marker testing, was objecting to the litigation moving forward based on the idea that essentially parentage had been established and could no longer be challenged based on the statute.
But there's tests now that you can tell who the parent is.
So there's a disconnect often in the law between biological parentage and legal parentage. So here there was a legal parent, and what the alleged biological father's argument was that legal parentage could no longer be challenged based on the application of this statute. So I talked with the judge about it extensively. We set up a briefing schedule to get some arguments on, you know, whether the case could even proceed, and ultimately decided that it could proceed and sort of see what would happen and whether there was an application of this statute and whether there were any other factors that might come into play about whether paternity could be established. And there there is a line of cases saying that children have their own independent right to seek to adjudicate parentage. So that was partly an issue.
Excuse me, well, one of the things that, my frustration is when I read these cases, I don't know the rest of the story. And so, my question was, where was this child for 2 years? Who had custody? Was there a biological mother? All of that I don't know. So, so did all of a sudden this man appear and say, I believe that I am the father? I mean, how did this all come about, and where were you? Who were you supporting or defending or helping?
So I was neutral because I was working for the court, but I was giving information to all of the parties, and at least for some of the time, some of the parties were self-represented. So I was explaining to them, this is the reason that this is a complicated case actually, and here's this legal standard that the judge has to grapple with. And so what happened is the child had been with the biological mother the whole time. The mother had been in a relationship with the legal father, but when he began to suspect,
So the legal father.
the person on the birth certificate who had signed the voluntary acknowledgement, correct. And at some point in the child's life, he began to suspect that he might not be the biological father, and they had done an out-of-court genetic marker test. And so the allegation was that they had conclusively established that he was not the biological father, and the mother thought another person might be, and he was the one objecting to the action. So while this case was pending, there was a case out of a different county that went to the Supreme Judicial Court. It was a different issue, but it involved that 1-year challenge period and whether there could be a later challenge to a voluntary acknowledgement of parentage by someone who had had no notice that that document was signed and nothing to do with it. And the Supreme Judicial Court held that that person was precluded from any longer challenging that document. So that applied to us. So that ruling, then, we put our heads together and interpreted that to say actually that that kind of ended that litigation. So that was not something that could be challenged any longer. So it was sort of an example of time when sometimes, the law being what it is, judges have to neutrally apply that law, even if sometimes your heart sort of feels for this kiddo and sort of the parties. We were bound to follow that precedent, and that dictated the outcome of that particular case.
Well, I just think that judges are so different today than it was probably 30, 40 years ago, because you have all these testing that you can tell that they didn't then. So I don't know how much case law you have, that you have so many different things that you have to face today. Well, I ask people this because it was very concerning to me. And the only counsel that served with me was Counselor Atty. I wish he was here because he would tell you too what happened. But anyway, I read this in the Boston newspaper. This is how I found out. There was a judge on the probate court, and she had a woman before her who asked for removal of a child, 3, that she had toddlers, and she was asking to move to Oregon, across the country, with these 3 children. She had no place to go there. She had no job waiting. She didn't know anyone. She didn't have family. She didn't have a friend. And so anyway, I just wondered how you feel about removal. And let's take just that particular case. And there really isn't any more that you have to know to tell me what you think. And it said that the judge, she gave an hour visitation to the father in Massachusetts on the computer. Now, this father was, as I read about him and everything, he was a very loving father. He didn't live very far from where the child was living with the mother and siblings, and he would be there, anything that they're involved in. You saw them almost every day, and even Christmas Eve, he would go there and stay overnight when they opened their Christmas presents. So he was a very loving father. So, I think about, her ruling an hour visitation on a computer. Can't hug a computer. So what this was completely keeping the father from the children. There was no way he could see him on weekends. There was no joint custody. There was nothing that you could do. So I'm just wondering, how would you have ruled?
So certainly those types of cases are some of the most difficult cases that judges face. Based on the facts that you've said, I don't think I would permit removal So the first thing a judge has to find is that there's a real advantage to the parent who's seeking to move. And it doesn't sound like in this case there was from what you've said. And the second piece is that even if there is an advantage to that parent who wants to move, if it would disrupt the relationship between the parent and the non-moving child in a way that was not in the child's best interest, this is a time when the child's best interest takes priority. So based on that, it seems like it would be the geographic distance, there would be such a disruption and such an inability of that parent-child relationship to continue. I don't think I would be inclined.
So the basic criteria you would use for removal is?
So a best interest, real advantage to the parent who's seeking to move, and then the best interest of the child. And you have to have both, but if there's a contest between those two.
What about the other parent?
So the other parent's interest comes into the child's best interest. So you look at things like the disruption to the child, their schooling, their social life, and their relationship with the parent who's staying. So obviously, if we were talking about removal, if someone lived on the North Shore and we were talking about removing to New Hampshire, that might be a really different analysis than Oregon, you know, so ability of the child to maintain that contact with the non-moving parent is a huge factor in that best interest analysis.
I saw this as vindictiveness. I saw a cruelty, that this good father will have no relationship with his children. He will be a stranger in another state that they won't meet. And I just can't believe, I wish we could remove judges for making such a judgment. I really do. It's that important to that child, because every child deserves a good mother and father. And if they are a good mother and father, why take the fathership away from this man that he can't be a father to his children? So I will never, ever get that out of my mind. I will never. And you know something? The problem is for governors, counselors, we don't have a crystal ball. Mm-hmm. Someone can sit there and say everything. They could be like Mother Teresa, and we don't know. They could be racial discriminating, whatever, and they could be a good actor. And that's the biggest problem, because I've seen judges that have disappointed me. And I'm proud of the great judges that I have voted for. I really am. But, that concerns me. I like your answer, but I just think, how many other cases? That went viral, that went in the newspaper, because it doesn't happen that often, in those cases. So what do you think is the biggest hurdle in the probate court, and what kind of changes do you think it needs?
I think one ongoing challenge for the court is the number of self-represented litigants. So there are just so many people who can't afford to hire a lawyer. There's a very limited category of cases where we can appoint lawyers for people, so they're very few. And I've certainly seen people feel very uncomfortable coming into court. You know, the stakes are so high for them. They're representing themselves. We can point people to resources to, explain things to them, but at the same time, that's not the same as having a lawyer and having someone advocate for you and sort of shielding you a little bit from some of the difficult parts in court. So what I would love to see, if I could wave a magic wand, would be an expansion of right to counsel. I don't know if that'll ever happen, but that would be, it seems to me that some of the interests that we're talking about are so high that we have a right to counsel. And, if I'm a parent and someone is seeking guardianship of my children and I object to it, I have a right to counsel. And yet, as we're talking about, divorce and other actions can have just as much of an effect on someone's ability to maintain their relationship with their children. So that would be amazing. I think that would go a long way. And in the meantime, we get by with encouraging volunteer lawyer programs. There's some grant-funded programs, and the court works really hard to cultivate relationships with programs that provide pro bono legal assistance and advice to try and help to level that playing field a little.
Do you have the guardian come into this involvement or what?
Guardian ad litem. Yes, certainly the court has the ability to sometimes appoint counsel for children, which can be very helpful, and also appoint a guardian ad litem, particularly to help with some fact finding. That can be a really helpful tool to judges to, if the parties have a difference of fact, they're saying different things, that can be very helpful. And sometimes we can appoint also a psychologist to do some evaluating if necessary. That can be very helpful.
We met for a very long time, but I want the public to know your different positions and to explain your position as a family lawyer with that. in some of these things, judicial case manager, and tell people about your involvement with the criminal defense in Brooklyn, because I don't know how many people here know what's happening in Brooklyn. So if you want to explain these different positions and what you play in.
Sure. I've had kind of, I think of it as three as a lawyer. The first being a full-time public defender. So I had a very high caseload in court every day, spending a lot of time in jails and lockups with my clients. And I did that for around 6-year period of time. Then the next chapter, I was in private practice. So I was, I hung out a shingle and I was working for myself and juggling different types of cases and types of clients and trying to, keep it all going without I didn't have a support team. So I was just me doing that and doing a lot of probate work in that time as well as appellate work. And then the third chapter on the staff of the court, first as an assistant judicial case manager and now as judicial case manager. So really, as Judge Crawford and Ann have described, really offering a lot of legal assistance to judges, as well as quite a lot of interaction with the public and staff in terms of being a legal resource, the court's legal resource or one of them. So offering information, answering questions, assisting with complex legal issues, trying to explain that to parties, creating policy for the court, and then being a liaison for the public. So a liaison with the bar and other organizations that we interact with frequently.
I have to interrupt now. So Counselor, your time is up.
Excuse me?
Your time is run.
Time is up, isn't that wonderful? I question. This is a new rule. This is a rule with this council. It never was before, because I want people to know how qualified you are. And if I'm a little off today, Counselor, I'm sorry. I had another death in the family, and my nephew has died, and his funeral is Friday, so I'm a little off today. So if you'll excuse me, but I want to thank you for all the time. And can I ask just one more question? Out of all these positions you had, which is the one that you think gives you the most credibility to be the best judge?
I think it's this last chapter, since I've worked on the staff of the Probate and Family Court for almost 11 years. So I've gotten to work so closely with judges. I've really seen the job inside and out. I feel very comfortable that I understand the requirements to be a judge. I think I have I've gained a very thorough knowledge of the laws. And so I've really gotten to see it up close and personal and feel confident that I'll be able to do it as well.
Well, I'll tell you, this is a very special court to me, being a mother, being a grandmother. So thank you.
Thank you.
Thank you. I'll pass it over to Counselor DiPaolo.
Thank you, Counselor. Good afternoon.
Good afternoon.
I heard and read reports from your home counselor that you had a hearing in, was it Northampton?
Greenfield.
Greenfield, oh, and I heard it went very well.
Very nice.
I heard there was a lot of support there within the community. I want to hear a little more specifics on some of the values you bring to the role potentially. I've heard you talk about understanding intergenerational trauma and also implicit bias insofar as it may exist in certain instances. And I'm wondering if you could elaborate on either of those by sharing an example you've seen in your career. It doesn't have to be your own, but where somehow you thought bias played a role in a decision or an action that perhaps weren't levels maybe around parenting, family structure, best interest of the children as far as education or other matters. I'm wondering if you can conjure an example of where you saw that.
One thing that comes to mind immediately is what I have seen with folks in our family wellness court, as we call it now, the drug court, family treatment court, is their articulation of the stigma that they have felt because they are a parent with substance use disorder. So I think people make a lot of assumptions about parents and parenting ability and make some moral judgments sometimes about people, which we try very hard to address that stigma, but I think folks still feel it. So I've certainly heard people in our wellness court articulate how grateful they are that that's not the experience they're having in that court, but I think we're the exception and not the norm. So I think there's a lot of bias around that and a lot of judgment around, someone who has a substance use disorder. People make a lot of value judgments around that.
I think there is some bias about people who use medication-assisted treatment. So I'm thinking back to a case that was, I believe, in front of Judge Crawford many years ago, where one of the parents had taken methadone for many years, was very successfully handling an opioid use disorder, and the other parent was really making hay with that and trying to persuade the judge that the other parent was not a fit parent because of that. So I think there's definitely bias and stigma that I still see around that. That's the first thing that comes to mind for me.
So potentially a parent utilizing MAT is doing the responsible thing.
I think that's right.
Trying to review what other issues are present.
Yeah.
How about as far as intergenerational trauma goes? You mentioned it. I mean, does that play a role in your work on the bench when you're elevated there?
I think that it does. You know, what we see a lot, there are some members of our staff who've been there for a long time. And so a new case will get filed. And sometimes our probation staff will say, oh, I worked with their parents. So we see, you know, we see sometimes some of the same families coming through generation after generation, some of the same cycles. And I am always mindful that, for example, if we're hearing a restraining order, if the judge is hearing a restraining order and there are children, and sometimes, you know, come out that the children have witnessed a violent incident between the parents, wondering what is the impact. You know, I think there's so much research on the very bad impact on young children of being exposed to that kind of violence, and you know, I'm concerned about what happens to those kids. Are they able to get the resources that they need? I'm conjuring a time when a young woman came to get a restraining order. She had her child with her. He was very young, maybe 2, and he was saying to her over and over again, why did daddy hit you? Why did daddy hit you? Why did daddy hit you? Clearly, he was reacting to the trauma of this event. And in our community, it's not that easy to get a child to therapy. And I worry about what happens there. And I hope that the court can be a place that we at least try and help steer people towards resources so that they have some tools to try to stop some of those cycles so that they don't keep repeating.
I love the notion of trauma-informed court, and I know the probate court has such difficult work. It does a great job supporting families that come through there. I watched with interest some recent debate on legislation that kind of intersects with the probate court. And it was about the fact that, and this is certainly not the court's fault, this is the reality of people's lives, that in some cases the fear of losing child custody deters victims of domestic abuse from coming forward or reporting that abuse. And I'm wondering, is there a role, and again, this isn't the court's fault, but is there a role for courts to play, do you think, in trying to address that? And if so, what would it look like?
Yeah, I certainly hear that concern that people might not feel comfortable bringing those concerns to the court's attention. I think that the role of the judge is to be very careful and attentive, because what I've observed is that often a victim may not even report that there's been violence for one reason or another.
Right.
It may come out slowly over time as someone perhaps gets more comfortable and feels like they can bring things to the fact finder. I've also seen situations where the person who's been the abuse victim may not even really fully understand that it has been abused for a period of time. And sometimes it's when there are other professionals like a lawyer for the child or a guardian ad litem that say to the judge, I'm very concerned about what I'm seeing here. There is a statute that if there has been an incident of violence, it is presumptive that the perpetrator not awarded custody, although that's a rebuttable presumption. That's a starting point. So I think if people understand that, they may feel more comfortable that they can be candid about the experiences that they've had.
Is there a way for some of these pro se folks to know that?
It kind of goes back to my answer to Councilor Devaney earlier, but there are court service centers in many of the courts. So if people are able to utilize those resources, I think sometimes domestic violence advocates will inform people of that, but it's certainly a place where lawyers would be helpful.
Among the many activities listed in your application is a training program for CASA volunteers in juvenile court. Do you remember that? What is CASA? What is the CASA organization?
So it's court-appointed special advocates. In the juvenile court, they play a role that they don't play in the probate court, so we don't have them. But we were asked to give them some training on the family wellness court and about substance use disorder, and to see whether there was a role that they might play, kind of bringing their advocacy on that behalf of children into the family wellness court.
So they're advocates for the child. They're not, do you know about the way to put that in juvenile? They're advocates for the child, they're not GALs.
I know something about it, so I don't know a huge amount, but my understanding is that they're appointed, that they're objective, and they will identify concerns and issues and advocate from their perspective what the child's needs are, right? I think it is different than a court investigator and a guardian ad litem, which they have in the juvenile court. That's my understanding.
And it's all volunteers.
Yes.
Yes. I'm not in the probate court at all. Is there a need or a role for expanding that volunteer organization into probate court at all? Is there a need for children to have independent advocates there beyond, and I understand there's mechanisms that exist, but they play a very particular role in juvenile court that's not otherwise addressed. So I'm wondering what you think about that.
That's a really interesting idea, and I'd like to think about it a little bit more. I can see pros and cons to it. I think what I have seen is lawyers wish that they could get an educational advocate. Like there are times that kids need really particular kinds of advocacy, which may be outside a lawyer's wheelhouse. And I don't think we currently have the authority to make those kinds of appointments. The juvenile court does. And so, you know, if there was something analogous, because particularly if, let's say, a caregiver is a grandparent or someone who's not a parent and needs to try and get resources, particularly if kids have been through trauma, there may be kind of special needs that they have, and they may be struggling to get them. I know we often hear people, you know, with challenges about IEPs and kind of getting schools to meet children's educational needs. Right. I think that would be really interesting. Sometimes my hesitation is that sometimes I think that there's a concern that folks can be kind of co-opted by one of the parents. So if there's adversarial litigation between parents, you'd want to make sure that whoever that person is not kind of getting aligned with one of the parents and really keeping neutrality. And so I think with volunteers, you know, with guardians ad litem, the court has very thorough standards that have to be followed and a pretty rigorous training program and vetting process. I don't know what that process is for the CASA folks. So, you know, I would want to make sure that there were similar kinds of training and understanding of the role that they were playing. But I think it's an interesting idea.
I'm glad you talk about education, because all of this intergenerational trauma creates social and emotional disabilities that manifest in school that I think the kids are floating through and they're not having educational advocates, so they're flaming.
That's right.
And the outcomes are not very good. And I don't have the answers, but it's great to hear potential probate judges thinking about those issues. And I hope trying to find ways that in one way or another, we all can contribute to steer this in the right direction.
Absolutely.
So I have no further questions. Thank you very much, Councilor.
Thank you. Well, so I don't have a ton of questions. I did want to mention, Councilor DiPaolo alluded to it, we did hold a local hearing. Very well attended and enthusiastic support shared on your behalf. And I did coalesce that into a report that I shared with my fellow councilors and submitting into your record. In addition, my inbox was flooded. This is a printout of all the emails that came in supporting you. Over 20, I didn't stop and count after that point, but a lot. And universally, enthusiastically in support and you know, asking for us to confirm you immediately. So I am also submitting this into the record. It's not so much questions as I just wanted to give you an opportunity to talk about two things a little more if you want to. And one is the creation and the work that you've done with what is now the Family Wellness Court, because I have so much respect for how that came to be and the kind of work that you do there. And the other is kind of just of interest to me is the collaborative relationship you forged with juvenile court and case management that I think deserves a little bit of airtime, if you will. So I just want to put those out to you. Just anything further you want to share around those issues.
Sure, and those are denefinitely connected, related issues. So I'm happy to speak more. really working with the Family Wellness Court has been such a privilege and one of the most rewarding things I've done in my time as a lawyer. As Judge Crawford mentioned, when she and I both came to the Franklin Division, we really were just under siege with the opioid epidemic and people, a lot of emergency custody cases, unfortunately, a lot of overdoses and you know, parents dying and leaving children without caretakers. And so it really felt like we wanted to try something different, and historically judges, I think, didn't have a lot of tools to be able to assist parents and yet had to preserve child safety, and so sometimes had to curtail contact between parents and children. So we looked at what the district court was doing. We had very few models to follow, so we were kind of, you know, figuring out what pieces from a criminal court context worked in probate and family court, and there were many that didn't. So we've gone to 1,000 conferences, it feels like, and gotten great education and training from the people who do establish family treatment courts. They're typically in the juvenile court context, so ours was a little unusual. But we really tried to bring a trauma-informed perspective. We tried to be very thoughtful about the language. You know, we literally looked at our own language and vocabulary so that we were not using things like a dirty text. You know, we changed how we were talking about substance use disorder. We were really lucky to get great insight from people who really know this. So there's a woman named Dr. Ruth Poteet, who is a Franklin County native, but an absolute now national presence on the neurology of addiction, and just a phenomenal person and resource. And so she was helpful to us. We worked with the opioid task force in Franklin County. So we got a lot of education and really, you know, I learned things, you know, and I had my own biases that I recognized about, you know, some substance use disorder, and was really able to educate myself and sort of change how I thought about things, or expand how I thought about things. And so it's been a remarkable success. Like, we've had over 50 graduates. We've had, I think, maybe more than 100 people come through the court. And in that time, just to witness people's journeys has been really incredibly rewarding. We've had a lot of reunifications happen, and then also a lot of less conflict in parenting in the probate and family court cases. People able to learn to work collaboratively together to manage one parent's substance use disorder and gain back some trust, which has been really wonderful to witness. So we have had this great partnership with juvenile court. So I've certainly learned more about that court and worked very closely with the assistant clerk magistrate there. So they refer cases to us, and so we have this great referral mechanism and collaboration back and forth. It has required a lot of, you know, thinking through things because juvenile court matters are impounded. So we had to change some of our procedures in order to protect that confidentiality. And we wanted to be very thoughtful about what information we send back, because the juvenile court judge is insulated from finding out what happens in the family wellness court unless the person who is the participant chooses to open that door. So we had to kind of be thoughtful when we were creating the communication mechanisms back and forth.
I love it, and I have nothing but, I'm just so inspired by the work that you're doing and the impact that it literally, the impact it's having on families, and then the community by way of that, the work that you're doing. So thank you for all of that. And I have no further questions for you. Thank you all for coming, but with that, I'm going to close your hearing.